Ready when you are.
Great. And my cable? Oh, it's here. Oh, cool. Let me get my cell phone. Okay, everyone, we're going to start in a minute. If you could find your seats.
Say something to them.
Yes. Okay, you can say it now.
Hey, before we start, we're going to pass around a roster. Before we start, we're going to pass a roster around at the break, just to verify that your contact information is correct. And it also asks if you would like your information shared with other commissioners, just to initial. So we had something that came up and one of the commissioners wasn't able to contact the other commissioner. Can't obviously prefer that you not be talking about commission business, but if somebody needs to reach you or somebody has a question that they don't know how to reach you other than going through us. So if you'd like to share your information with the other commissioners, then please just initial as it goes around and it'll come around at the next break. Thank you. Thank you.
So good morning, everyone. Just big picture where we're going for over the next 2 days, because it is very unusual what it is we're doing. So today we're going to be focused on two. And a lot of us worked very hard. Matter of fact, everybody here worked very hard on the language. So we're going to be taking another look at that and hopefully making it clear as can be. And today, I'm guessing 10, maybe we'll be done by 2, maybe earlier. So it won't be a full day. That's again, my best guess, because we're gonna have lots of discussion. Tomorrow should also be a pretty quick day. Maybe ending around 12-ish, again, depending on how things go. And today we do have lunch. Tomorrow we haven't planned for lunch yet. I want to remind everyone to be here at 8:30 tomorrow for the photograph. And we're really counting on all of you being here. Manny, is there anything else you want to say before we start? Okay. Ms.
Just need a
Strickland?
couple minutes to kick it.
Okay,
You ready to go?
I'm ready to go. Tell me when? We're good. Okay. Ms. Strickland, will you please take roll call?
Barcelona. Ron.
Here.
Brazil.
Here.
Donaldin.
Here.
Doyle. Dudley.
Here?
Ewell. Gordon.
Here.
Long. Marsh. Nieto.
Here.
O'Rourke.
Here.
Thank you.
Okay, does anybody know if Jeff Long is still coming?
He is enjoying himself out of the country.
Thank you. Okay. No further details required. Thank you. Okay, I would like to introduce Acting Advisory Committee Chair, Chief Jason Salazar. Welcome. And to my immediate left, William Toby Darden, our chief counsel, I guess, or our attorney, our general brilliant lawyer at our table. And to my right, Post-Executive Director Manny Alvarez is to my right. This is the time set aside for members of the public to comment on items on the commission agenda. Pursuant to commission policy, the commission chair will manage the public comment in deference to the commission's workload and meeting time constraints. Up to 15 minutes is allotted at the beginning of each commission meeting for public comments on items on the agenda. Based upon recent events, more people than usual may want to address the commission. Therefore, if required, we will go longer than 15 minutes, but may limit this period to no more than 1 hour, as we have many topics to cover on the agenda. Members of the public who wish to speak are asked to limit their remarks to no more than 5 minutes each. If we have many people who wish to speak on the same topic, I, as the chair, may intervene and will ask that you limit remarks to no more than 1 minute. Pursuant to existing commission policy, the chair may conclude the public comment period if multiple speakers are voicing repetitive or similar statements and the 15-minute public comment period has expired. Please be advised that the commission cannot take action on items not on the agenda. Please remember that this meeting is being transcribed, so I may politely interrupt and ask you to repeat or speak slowly and clearly so your comment can be correctly captured in the transcript. At this time, is there anyone who would like to address the commission during public comment? Seeing no one, then we will move to the executive director's comments. At this time, the executive director would like to address the commission. Manny?
Thank you, Madam Chair. Thank you, commissioners, for coming back after a month of participating in the SB2 discussion. We appreciate your hard work on it on April 7th and your hard work today, and obviously what you'll be doing tomorrow. We held an advisory committee meeting yesterday, and one of the questions that came up during the advisory committee meeting was whether we were going to be able to make the timelines for SB2. And of course, we will. Kind of addressed it with the advisory group is there really are, I don't want to say challenges. Challenges is not I don't think the right word for us at this point, because I don't think we necessarily have any challenges. We've worked through the challenges. We just have some stressors in terms of SB2. I'd like to just kind of go over some of them with you. And I know my colleagues will be kind of going over some of them in greater detail. But one is the timing. Obviously, we're working on the timing issue in that the implementation has to be done by January 1. We have some timing issues with hiring staff, with getting our budget approved, which won't happen till July 1. So timing is definitely a stressor for us. We've had a lot of discussion about a software solution, and we're going to brief you on that. Today, we do have the software solution kind of moving forward, but getting it implemented is going to be a little bit of a challenge for us. Staffing will be a significant challenge for us. Obviously, there is a labor shortage in the United States, and we're no different. Hiring 127 people, should the budget get approved by January 1, is going to be, I don't want to say impossible, because nothing is impossible, but it will be a significant challenge for us to get that many people on board by January 1. And the likelihood of having 127 fully on board is it's not good, but we should have a majority, hopefully a significant percentage of the staff on board. So in terms of the process, we've kind of been communicating just kind of our ideal process and what it should look like. And this is just my opinion that I've shared with the staff. It's really 4 things. One is it has to be a fair and uniform process. And what I mean by fair is the community has to believe that we're doing this properly, that we're acting independently, and that we're being thorough, as do the law enforcement professionals that are going to be impacted by this. It has to be a uniform process in that everything that comes to the board and everything that comes to the commission should look exactly the same. The verbal delivery should be the same. The paperwork that you all receive should be the same, and it should be identical as we move along. It should be professional. Obviously, that we should treat the process with respect and assign the right people to it. That it should be timely. Obviously, Senate Bill 2 gives us 3 years to process these revocation proceedings, but 3 years for anybody who's under some form of scrutiny or has been notified is not a good thing, as we all know. It's not fair to that person. It's not fair to anybody to drag it on. So it has to be timely. And then really lastly is it has to be transparent. Everything that we take into consideration should come to the board, and everything should come to the commission, and everybody should know exactly why the process is going on. So those 4 things: fair and uniform process, professional process, timely, and transparent. So hopefully we can hit the mark with all of that. I'll now defer to the rest of the meeting and ask the chair for permission if we could have Bureau Chief Jackie Nelson come up to the table, and she may be joined at one point by Bureau Chief Scott Campbell. I'll defer to them, but she and Scott have been leading the charge and have a lot of the answers to a lot of the questions. That's it.
Thank you.
for
Any
me. Thank you,
questions for
ma'am.
Manny? Okay, let me introduce, before we begin, I'll be calling upon Bureau Chief Jackie Nelson to provide us with an update on SB2. We'll be starting with agenda item F, report on the adoption of Commission Regulation 1205, the definition of serious misconduct. So you may recall That is the overall big definition of serious misconduct that we spent a fair amount of time on at our last meeting. So at this point, Jackie Nelson, SB2 Transition Team, will provide us with a report on this item. Thank you, Jackie, and welcome.
Good morning. Thank you, Madam Chair and members of the commission. So this morning, I want to give you to start this day off with an update on what has happened since the last commission meeting that occurred, the full commission meeting, which would have been in March. So starting off, I want to advise that there are now 9 full-time personnel working on the transition team, including the addition of a second bureau chief, Scott Campbell. The additional staffing to this project has been significant in allowing us to be successful in reaching our goals, as Manny just talked about. So first thing I want to cover is that the budget change proposal submitted by Post to support this initiative has been approved by the governor and is pending final legislative approval. So the total funding amount currently is $22.6 million for FY 22-23 and $20.6 million for FY 23-24 and ongoing. The number of additional positions received for SB2 is 127 positions, which nearly doubles the existing size of Post. So these positions will primarily make up a new division, the Peace Officer Standards Accountability Division. The division will contain a minimum of 5 new bureaus, which will include an Intake and Disposition Bureau, Certification Bureau, and at least 3 professional conduct bureaus, which will be the investigative bureaus moving forward. In order to support SB2, there's going to be that additional staffing necessary, which will also include an assistant executive director to oversee the new division, a legal bureau consisting of a chief counsel and 7 attorney positions, additional staffing for the executive office, human resources, computer services bureau, administrative services bureau, and strategic communications and research. So staff has completed the majority of the duty statements for each of these positions and are working on the hiring strategies. Several of these positions are currently open and the recruitment process is well underway. Other positions will be posted soon, and we will continue to maximize our recruitment efforts. With the additional funded staffing, we've been working on identifying office space to accommodate the increase. We are working with the Department of General Services Real Estate Division to identify suitable space. These discussions are ongoing and we feel we're making sufficient progress at this time. So one of the biggest endeavors since the last meeting has been the procurement of our IT platform to support SB2. So at this time, I would like Computer Services Bureau Chief Colin O'Keefe to provide an update on this, and then I will continue my overview afterwards. Thank you. Colin?
Thank you. Good morning. Colin O'Keefe, Bureau Chief for Computer Services here at Post, and I'll provide a brief update on progress for the various technology components related to Senate Bill 2. So as a recap, at the March 2nd commission meeting, the commission approved staff's request to enter into a contract with a vendor to procure a case management system in support of the investigative review and storage requirements presented by SB2. Prior to the commission's approval, law enforcement consultant and technical staff spent several months evaluating vendor systems for business suitability and identified the Mark 43 case management system as meeting the most business requirements created by the bill. Staff also engaged continuously since late 2021 with the California Departments of Technology, General Services, and Finance by submitting business analysis plans, budget change proposals, and to seek technical approvals and purchasing authority for funding the project. So as far as forward progress since my last report to the commission, on May 3rd, Post did receive project funding from DOF, and we immediately awarded the contract. On May 18th, SB2 staff, executive staff, and computer services staff held the project kickoff with Mark 43 personnel, and we set high-level expectations and timelines for the project. So we're now fully engaged with this procurement. While we're still early in the implementation, staff and the vendor are reasonably optimistic that we can be ready for the January 1 operational deadline. So in addition to the case management implementation, staff continue to work on modifying some internal systems and processes, to support the other workflow requirements of SB2. And just to include expanding EDI to accommodate non-post affiliated agencies, changes to notices of appointment, implementation of proofs of eligibility or POEs, suspension and revocation of certificates, affidavits of separation, as well as processing of felony and other serious misconduct records provided by California Department of Justice. And finally, reporting requirements both to the public and to the legislature. So most of these internal development items are in the working model or prototype stage at this moment. So we're fully engaged with post-LEC staff on testing these components, and we are confident that the internal processes will be ready for January 1. That concludes my update on the technology components, and I'm happy to answer any questions after Jackie completes her presentation. Thank you.
Any questions on technology? At all? Yes, Commissioner
It's
Doyle.
not a question on technology. Just curious, how, Manny, did you come up with the structure of the new bureau for this?
So we had a significant amount of discussion in the fall as to how we were going to staff it. We ultimately came up with this model, and then we put it in the budget change proposal that was submitted to the Department of Finance in the month of November. Ultimately, they gave us the verbal approval in December, and it was made public in January. So we did all of that in the fall of last year internally. We've had some, slight modifications, some slight adjustments that we'll have to make very clearly as we move along. We just had a discussion yesterday about some potential changes in terms of how we would staff it. But the biggest unknown right now is the volume and how we're going to address the volume. There are three review bureaus. We're not unclear. It's not known to us if that is going to be sufficient. We think that we can use the existing personnel that are in the BCP to create a fourth unit, should we need to have a fourth unit. But for now, we're going with 3 review units, 1 certification unit, and 1 intake unit. And then separately assigning the Legal Affairs Bureau directly to the executive director that has a staff, I believe, of with the chief counsel of 14 individuals, 8 of which are attorneys, 1 supervisor to assist, as well as 4 analysts and 1 office technician. So they'll be separate and assigned to the executive director, not just for SB2 matters, but primarily to handle SB2 matters. Right now, a lot of our legal work, most of it is done by Cal DOJ. So hopefully we can bring that all in-house, and that some of our other staff can leverage the Legal Affairs Bureau, as we're calling it, for EEO matters, reasonable accommodations, internal investigations. So that is going to be a significant unit that will be separately detached. And then obviously there's probably, as Jackie mentioned, I want to say about 15 different positions that are needed to support the increase in staff. We need HR people to process them, to handle all their HR affairs. We need computer folks to get them technology, emails to support them as such. And then obviously Jackie mentioned the Strategic Communications and Research Bureau. That bureau handles our Public Records Acts requests, and we anticipate that there is going to be a significant increase in Public Records Act requests. So that's why they're gaining 4 or 5 people as well to handle PRAs. Thanks, sir.
Madam Chair, I do have a question for IT.
Please.
So with Mark 43, I'm assuming it's going to be cloud-based, or maybe it's going to go on a server. And you said by January, they are certain, or you're pretty sure? Because that's a pretty aggressive implementation timeline, only because I'm adopting Mark 43 right now for my records management system, in my agency, which usually it's about a year for implementation. Well, for the other chiefs, there were some concerns because I just came from a meeting about how the records are going to be transferred. Are there going to be add-on apps if you already have Mark 43 that you can now transfer it directly? Is it going to be PDF? Is Mark 43 going to autofill? So all those IT things that people don't think about, but they do when they're using the system. I guess that's my question or comments.
Thank you.
Please go ahead. Connor, did you want to say something?
Yes, thank you for
Thank you.
the question. So there are a few different components there. You're right, it's a very aggressive timeline. The average implementation for Mark 43 is 1 year. And so we're looking at a little over half that. Again, we're just at the kickoff stage of this, so all we have is the say-so of the teams that came together to start putting timelines to this. And we're thinking there's probably about an 80% chance we can get this done by by January 1. So it's not a sure thing, but we're optimistic at this time. And the reason for that optimism is that we don't have any legacy data that needs to be ported over to the system. You're correct, it's cloud-based. Normally there's a transition period where you're moving off of one system and onto another. And so that legacy transition, moving the data into the new system, does take quite a bit of time to normalize and get it into the new system. So in this case, we don't have that, since this is a whole new set of authority that Post is being granted through the bill. So from a certain point of view, it's a simpler startup than what's going on probably in your agency or with CHP. So we're optimistic, but again, I can't tell you with 100% certainty. As far as add-ons, we specifically phased this out to keep it a very clean installation to get us to January 1 and get us as far there as we could do to support the intake of data. There will be no add-ons to begin with, no APIs talking to external systems. And we purposely said that as part of our requirements to get a quick, streamlined implementation. So for the following phases, there will be change requests to tie this thing into EDI, and that'll take time. Did I cover your question there? Okay, thank you.
Amy?
Thank you, Madam Chair. If I may add also, during the kickoff meeting, it seemed to go very well in terms of Mark 43 and the timelines. They gave us some pretty decent assurances that they're going to be able to do this for us in a timely fashion. We also asked that it be ready for the most part several months before, so we could train our staff and we could train the field on how to use it. So we're hoping that it's not going to be simply ready to go on January 1. We're hoping that it will be ready before January 1.
But it's also impossible to know how many cases we're going to have. And so we're really kind of stuck to how much resources do we put into this at this point, but time will tell. Anything else on IT? Okay, thank you. Please, Jackie, go on.
Thank you very much, Madam Chair. So moving on with the update, staff has held 2 separate workshops with different stakeholder groups to create the content for the 40-hour course required for the Peace Officer Standards Accountability Advisory Board. It's expected that this course will be completed by early September, which will allow us to pilot that course before it's actually presented to the board. So it's our intent to make this course available to anyone sitting on the commission as well to learn about the decertification process. Difference from the commission to the board is the board, it's a mandatory attendance. It would be optional for commission members if they would like to attend that course. So as of right now, we only are aware of 1 member that's been appointed to the advisory board, the Accountability Advisory Board. The first member appointed is Ms. Elizabeth Bushin, who I believe was appointed by the Senate Pro Tem. This leaves 8 more seats to be filled. So we're anxiously waiting to be able to get that board completed. Post staff continues to work with the Department of Justice to solidify the criminal conviction reporting requirement. We are finalizing a memorandum of understanding between Post and the Department of Justice and hope to have that completed soon. This is obviously a necessity as we move forward and one that we'll rely upon heavily. So a big part of SB2 is the unknowns and the lack of information to the field and the public in general. So we're continuing to do a lot of outreach to the field. Agencies are eager to get information on this initiative. And several things we've done and are doing include, and I'm just going to give you an example of some of the stuff we've done. So we attend law enforcement meetings to provide overviews to groups such as the chief and sheriff's meetings, training manager meetings, background symposiums, and individual agency requests, just to name a few. We're getting a lot of requests to come out and directly provide input to agencies. And we are trying to accommodate each and every one of those because the outreach of this program is extremely important. We've hosted 4 live online workshops, each targeting a specific area of SB2. Each workshop was recorded and has been placed on Post's website to be viewed at any time. Nearly 2,000 people participated in the 4 workshops. And since that time, the recorded versions have been viewed online over another 2,200 times. So that has been a very good resource moving forward, and people may refer back to that as often as needed. And we will continue to put out additional live workshops moving forward as we develop our process and the stages moving forward. So last week, staff just finished filming a newsreel style video with digital outpost. It's going to be similar to the AB 392 video that Madam Chairperson participated in and did so very well. I'd like your autograph when we're done, please. Thank you. And then we continue to leverage our regional consultants to push information out to the field. And we provide updated information in the regional monthly newsletters. The SB2 page on Post's website is continually updated with a large number of FAQs under each topic area as a resource. And then beginning in approximately August, Post will be doing detailed training sessions to the field throughout the state. This won't simply be an overview, rather, it's going to be the nuts and bolts of what agencies will need to do to be compliant with Post. So we anticipate each session to be at least 8 hours long, which will cover every aspect of SB2 from the hiring requirements all the way to the end of an officer's career. So a lot of outreach ongoing. So we continue to meet with the Office of Administrative Hearings to work out the administrative law judge process. The largest challenge has been, as we just talked about, is to estimate the number of cases that may reach the ALJ, which is important for their staffing needs as well as funding. It's estimated that the daily cost for an ALJ hearing is approximately $5,000. Funding for these hearings has not yet been determined. Staff is heavily invested in creating workflows and processes for each phase of this implementation. We're hoping to have the majority of this done within the next 3 to 4 months so we can properly train new staff as recruitment continues. One thing I'd like to add, Colin did a very good job at identifying some of the internal processes that are being completed. One additional one that I just would like to touch on is that we are adding a new classification for the agency roster for a background investigator. So, and we did this due to the fact that unless you are on an agency's roster, you will not be able to gain access to the National Decertification Index. So we created this classification since many agencies have civilian background investigators and they are not sworn. Currently, only sworn staff and dispatchers are on our agency rosters. So we've created this classification in order to help ensure that the background investigators are able to access that information. But I do want to point out that this is only for those civilian contractors, civilian investigators employed by a law enforcement agency. It will not apply to contractors or private background investigators. So we are also working on the decertification list. Not sure if that's what we're going to call it finally or not, but it will be the public listing of officers who have lost their certification due to separation, revocation, or voluntary surrender. This will include the name of the officer, a summary of the allegations, and the date of the action. This information has to be made public pursuant to the legislation. And so at this time, we are planning on housing that on Post's website so that it is in fact available to the public. Finally, as you know, today is dedicated solely to reviewing the SB2 regulations, both amended and created. There will be a total of 22 regulations presented to you for your review and action. I want to point out that we received 1 letter of public comment on the proposed regulations from the ACLU. You have all received the letter as it was attached to your agenda for reference as we go through here. And I will just say that you get to see a lot of me today, and I'm sorry and you're welcome, all in one little package. So So that's just a brief overview. Before we move into the first regulation, which is probably going to be our biggest regulation to tackle, are there any questions?
Wait 1 second. I think Manny would like to add to this or
Yes, sir.
Manny, go ahead. Go ahead, Commissioner.
I just had a question. You mentioned there's an investigative bureau what does that look like? I know it's just the beginning, but can you tell me what it looks like as far as what you've penciled out?
Are you referring to staffing or?
Yeah, the staffing, what that bureau will look like, who the people are that are, their
Sure.
capacity, that sort of thing.
So currently, we visualize those bureaus to each be overseen by a bureau chief, equivalent to myself. They will be staffed with 7 or more LECs per bureau who will be doing the case reviews and investigations as necessary. They'll be supported by as a staff services manager, I believe 2 or 3 AGPAs, SSAs, and also office technicians in each of those bureaus. And they will be the bureau primarily responsible for reviewing every one of these cases and taking it through the process as the process that we've identified and are continuing to identify.
Thank you.
You're welcome.
Thank you, Commissioner. Manny.
Thank you, Madam Chair. I have one thing now that you asked that question, just internally, Commissioner Barcelona just asked a question. Internally, Jackie and Scott's team, I presume they're getting questions about that. And they took an internal poll of the LECs that are in the building and their average tenure in law enforcement. And I want to say it was 25 or 27 years of experience for most of our LECs. So hopefully that'll give everyone a level of comfort that at least the people that will be doing the investigations or reviewing the investigations will at least have some experience.
Yeah, that's kind of what I was trying to get at, is the level of experience of those people, because obviously you want people who have done a wide variety of the job. And when they read stuff, they understand how things are going. And I think that we need to make sure that people with a lot of experience are in those positions, not trainees. That's what I'm sorry, I didn't clarify that. Thank you.
Thank you. And then I would like to just add just a couple of thank yous before we kick off to the regulations. First, obviously to Jackie, Scott, Maria, the entire team that's been putting all this together for the last 6 months or 9 months or a year, it seems like at this point. But they've done a great job, and thank you, Jackie, Scott, Maria, everybody else who's in the back of the room. Also, the Mark 43 software solution, which we've been discussing the challenges with it for the last couple of meetings, just to remind everybody, although we have a very robust budget for a post for 21-22, the money's in buckets, as we talked about previously, and we did not have sufficient funding to procure the software in our administrative budget. Basically, that's our salaries, these tables, paying the electric bill. So the Department of Finance and the administration was able to push through legislation to allow us to use money from this year to move money around. They had to go to the legislature. So that went through. Then they had a 30-day review period by the legislature. It caused meetings with the legislature. So thank you to the staff for pushing that through, as well as for the Department of Finance to get us that change. It seems like a simple thing, but it was a significant challenge. It took months. On top of that, Maria was pushing also to use some of the money for some of our staffing because obviously we're taking a lot of resources already outside of their regular programs, and we couldn't replace bureau chiefs and such. So they also enabled us to hire 5 additional, I think it was 5 or was it 6, 5 additional individuals, 1 bureau chief and 4 LECs out of this year's money for the future, for using the future position. So a big thank you to them. It, like I said, it seemed like a simple process, but it was a ton of effort for them to do that, and we're super appreciative. That's why we have the Mark 43 software solution moving now. And I bring it up because people may ask, well, why did you guys wait so long? That was the issue. Aside from getting all the approvals for the procurement from the California Department of Technology and everything else, we didn't have any money to buy it. And then we had to engage in a contract to do it. So we're a few months ahead. We were anticipating having to do this in July. And we're glad that we're moving forward now, at least with the software solution. So that covers it, Madam Chair. Thank you again for allowing me to speak.
And Manny, in terms of a ton of effort, absolutely, your staff has done that, but so have you personally. And on behalf of the commission, we really appreciate that. Okay, more to come. Please, Jackie.
Thank you, Madam Chair. So we're going to go to item F, as Madam Chair discussed, because this is the definition of serious misconduct, and it kind of sets the tone for the rest of this meeting. So we are going to refer to proposed commission regulation 1205. And if I could have Tobias pull up my PowerPoint on this, I would appreciate it. Thank you.
Now, before you go there, just to make sure everyone's on the same page, is there any requirement that we have an overall definition of serious misconduct?
That's a great question. There is not.
Okay,
So
so-
that's a preference by this body. It's not required.
Okay.
And I think there are varying viewpoints on how you would like to look.
Okay, wait one moment. So commissioners, it's important to consider this. We discussed what our definition might be. We're going to hear other information about that. One of the possibilities is to not have an overall definition, but rather rely upon the various areas that we discussed at length. So as you're thinking about the language, think about, does this really add to it, or does it take too many things away? Just for your thoughts. Thank you. Please go ahead.
Thank you. So Penal Code Section 1350.8 states the commission shall adopt by regulation a definition of serious misconduct that shall serve as the criteria to be considered for ineligibility for or revocation of certification. The definition must minimally include the statutory definitions listed in SB2, and those are the 9 items that we're going to get into. On April 7th, 2022, the commission deliberated the definition of serious misconduct and subsequently created a definition as required. The definition is attached to today's agenda and is listed as V1. The proposed language was drafted and subsequently sent both to the Office of Administrative Law and Post Agency Legal Counsel. Several areas of the proposed language presented with issues. As a result, Post staff, in collaboration with counsel, has provided suggested language for consideration for today's meeting. The suggested language is attached to the agenda and is listed as V2. So in order to provide the commission with a clear understanding of the suggested changes, I'm going to review this regulation one paragraph at a time. I've created a PowerPoint presentation to assist in this process as we go along. Staff will make the changes to this regulation as we go, so that we'll be able to present the final version to you during today's meeting, which will allow you to vote on this item. So if I can defer you to our PowerPoint presentation, we tried to make this very understandable by putting in color coding of the text. So as you see, any text that is in black is what's obtained or in the actual penal code. The text in red are the amendments that the commission requested during the special meeting in April. And then the blue text will be any suggested language by staff.
And again, one more time, since we met on this before and we came up with text, what was the problem with the text that we created last time?
I will, as we go through each one, I will identify what the problem was, what is, with the help of my esteemed colleague, Mr. Darden.
Perfect. Thank you so much.
You're very welcome. Okay, so our first slide is the overarching definition, which is what Madam Chair was just asking about. This is not a required content as far as the definition goes, but this is what was asked for at the special meeting back in April. So when it was reviewed by legal, there were some concerns which resulted in that review, and a suggested language was provided. So at this point, I'm going to ask if Toby would please further clarify the legal concerns around this. Thank you, Toby.
Sure. So again, the language in red is the language that we came up with at the last meeting. And the commission can certainly decide to go with that alone. As a lawyer that's litigated in state and federal courts for the last 30+ years, I always try to think, if I'm having to defend a legal challenge, if the commission was sued, and an officer where discipline was taken against that officer said, the language in red, the language that we came up with is simply too vague. It did not give me as an officer sufficient notice that the conduct I engaged in was going to be grounds to decertify me as a law enforcement officer. What would I like as a lawyer trying to defend the commission in terms of making arguments to the court to try to defend or uphold the language? And as I think I mentioned to you last time, I think I'd have certainly that argument with the language that we came up with in red. The courts, I think, are would be inclined, I think, to look at any given set of conduct or acts by an officer which were sufficiently severe and say that a reasonable officer should have known that that conduct would show that they did not have fitness to serve as a peace officer in California. So I'm not saying that the language in red that we came up with is indefensible. But as a lawyer, I always try to look for, is there any way that we can flesh it out a little bit more? Is there any way that we can give a little bit more definition to it so that we could better defend against a challenge in court that our regulation was too vague?
So Toby, let me interrupt.
Yes.
So to be clear, right now, the only language we have is demonstrating a lack of fitness to serve as a peace officer.
Correct.
That's the only standard that we've put out there. And Toby's position is a little vague. So now that's why we're jumping into part two. Okay.
So what I did is I just took a look at some of the regulatory and statutory language in other jurisdictions. I looked at some case law and so forth, and just came up with what I thought was language that would best communicate those circumstances which would be circumstances that would indicate a lack of fitness to serve as a peace officer in the state of California. Now, there are a lot of words up there, and I promise you I'm not paid by the word. The idea is really to try to capture a combination of circumstances which would help the commission best defend against a regulatory action to remove certification by trying to say these are the circumstances under which we would see serious misconduct. Now, one of the problems, and I will now criticize my own language, one of the problems that you could say that to the extent that the language is very broad, and this is extremely broad, that then that's going to create another problem. And that problem is agencies which are required to report acts which are potentially decertifiable acts, they would now end up having to report a significant number of events, which maybe they're things that the commission doesn't want to be to have reported. So it's always a balancing act, right? The question is, how do we come up with a regulation which is sufficiently broad to permit the commission to take action in all the circumstances in which the commission would believe it is appropriate to take action and decertify, while at the same time being sufficiently clear so as to give notice to the officers in the field. So I hope I explained that well enough.
Let me jump in again.
Yes, go ahead.
So you're going to end up having to make one of three choices, or actually four. One is no definition at all in black. The other is the very broad definition we've already come up with. The next is adopting some or all of the language Toby's written. And the fourth, I guess, would be creating something totally different that we haven't created before.
Correct.
Any questions about what you're going to be asked to do? Commissioner Doyle, you have a furrowed brow.
Wondering, Toby,
Yes.
what, don't you also sometimes refer to what's the legislative intent?
Absolutely. And so let me explain, Commissioner, the legislature gave a significant amount of deference to you all. And that is because what the legislature said is the commission shall adopt by regulation a definition of serious misconduct that shall serve as the basis for ineligibility or revocation of certification. And then it said that definition shall include all of the following, and it laid out the 9 specific areas. So that actually gave the commission the ability to define serious misconduct in a way that the commission saw fit, with subject to the legislative command that that definition had to include the 9 specific sub areas. It's 9, right, Jackie? Those specific sub areas. So the choice that the commission can make is it can adopt a regulation which, following the legislative command, simply says serious misconduct is, and then jumps to the 9. We could do that. Or you can have, as the legislature has said, you can adopt a definition of serious misconduct that services the criteria and includes the 9, but also is broader than the 9 to give you the discretion in the event that there are acts or omissions which do not technically fall within the 9 areas. It still gives the commission the ability to take action. So that's how I see it.
Okay. Any other questions? Commissioner Bresson? No.
I just like to keep it simple with how the bill is. We've already got the 9, and that also leaves the ability to apply whatever the situation is to those and then make a good decision out of that. I think by adding more I think it just gets us deeper into the pond, so to speak, and possibly problems. So my vote is, I'm not making a motion, but it's just a simple version.
So simply less is more.
Yeah, well, I think that the commission and the board's going to want, is going to want to be able to apply the circumstances to the bill. And there should be some room to maneuver there to take into account exactly what happened and make a good decision on it. And so I'd like to have that room to maneuver for the decisions that we're all going to be facing here. And so I don't want to close it in. I'd rather have some room. And I think that the bill already gives us what we need.
And let me check with Toby on that. So you understand Commissioner Barcelona's then. Do you
I
feel,
absolutely do.
do you feel the last thing he said, that those 9 areas already give us what we need in terms of flexibility? What are your thoughts about that?
So, I suppose we could do an intellectual exercise where we look at various combinations of acts that law enforcement officers have engaged in that all of us would reasonably think would lead to the need to decertify, and then try to determine if we could shoehorn it into one of the 9. And under those circumstances, I'm sure we could come up with something which didn't fit within the 9, but that all of us would nevertheless believe should be something that should result in decertification. Having said that, there's also an argument, and this is not my decision to make as a lawyer, it's the board as the implementer of the legislative language. There is something to be said for recognizing that I think this process is going to be a living and breathing process, and that we're going to have our hands full as it is, just trying to take the existing volume of cases that we're going to have and to try to interpret some of the statutory language in those 9 areas, which some of which is already fairly broad. And so it really isn't a legal determination. It's really just the commission's determination. Do you want to just start with what the legislature gave us and let's work with those 9, and then we can see what happens? It may very well be that we can have a report by the division, or events will come forward, will come to our attention, which the commission or the board would look at and would say, you know, we can't find a way to shoehorn this in. Maybe this is something that we should raise to the commission and have a new subsection, have a 10th or 11th or 12th. And so we could do that over time.
So to be clear, Commissioner, I'll be right with you. To be clear, your comment was this is a living, breathing document. So the exact circumstance you explained, we're in a situation where it doesn't fit within any of the 9, and all of the commissioners think, gee, we need to adjust the language to make sure that we would include this. Will it just be up to us as a commission to do that? Does it have to go back to OAL? Explain the process to all of us so we know how much we have to decide today and how
Sure.
much we can wait on deciding to see how this shakes out.
Sure. Well, we change regulations all the time. But of course, the process, and Jackie, you could talk to this, and your regulatory group could talk to this, but generally, a regulation is a law, and anytime we change the law and adopt a new regulation, it has to go through the regulatory process. Having said that, Post has been pretty good at being able to work with OAL, promulgating language, getting the commission to approve it, getting it before OAL, getting it out for public comment, and getting it adopted as a regulation. So I don't think it's, I mean, Manny, again, this is something I think you and your team could address, but it doesn't seem like it's a huge lift. Yes, it does have to go through the regulatory process, but it isn't insurmountable. It's something that the commission knows full well how to do if we decided we wanted to have a 10th and 11th and a 12th sometime down the road, but it would take a couple of months to get that done.
Any comments?
Yes, thank you, Madam
Commissioner
Chair.
Yule, I'll be calling on you next. Thank you.
And Mr. Darden, that's correct. In terms of the OAL process, yes, it would obviously have to go through the regulatory process. I believe we're doing 10 to 20 regulatory changes per year. Now, some of them obviously are much more challenging than others, but we do it regularly. As you all know, you vote on regulation changes. It seems like every commission meeting, and all those have to go wherever you're voting, have to go through the process. So it is a doable thing, but it will have to go through rulemaking whenever there's a change. Yes.
Thank you. Commissioner Yule.
Thank you, Madam Chair. Regulatory process notwithstanding. I thought
Is your mic on? Yeah. Thank you.
that, well, let me not make assumptions. I will just speak to the concern that I had last month, which was and still remains. If you don't have enough language to go around those 9 principles and something occurs and it comes to this commission and it does not somehow fit properly within those 9, you're giving a free pass to a bad officer. And part of my personal concern was the morality of allowing someone to go knowing that they violated principles of policing in the state. And so, as I was hoping that the overarching definition was to be broad enough to allow us to not have that problem. And so I still actually, I think the language in the blue is very attractive, Toby, but I still like the idea of a broad definition of allowing us to be able to still capture those people who are those individuals who violate any of those 9 principles or who are outside of those 9 principles, and still gives this body the opportunity to act.
Thank you. So Toby, the question is this. Situation occurs just like Commissioner Yule described. Something comes to us, we all feel that this person should be decertified because of this action. There is no place to put it in the 9. We decide, okay, we're going to change the regulation. What happens to that person who we all think should have been decertified, but there was no place within the 9 parameters to do so?
Okay, so this is a good example.
Was that it, Commissioner Yule?
This is a good example where I, as a lawyer, would like to be very careful in the way I answer it. So any situation like that, obviously, we would have to analyze the applicability. I don't want to say now that anything that's going to bind us in the future. But the general way I approach these legal issues is that when you are taking action against an individual, saying to that individual, your conduct on this occasion violated this principle of regulation or this principle of law. That regulation or principle of law needs to have been in existence, right? I mean, that's the basic idea, is that you don't want to have, what's called an ex post facto law. You don't want to say to somebody, well, you engaged in the behavior today and today it appeared to be lawful, but we're going to change the law tomorrow and then tell you that what you did yesterday was not proper behavior. And so for that reason, while, I'm not going to bind myself to any legal opinion on a future issue that may come to us, I think generally, if there's no way that we could shoehorn it into abuse of power or demonstrating bias or an act that violated the law and was sufficiently egregious, if we couldn't make it fit into one of those categories, I think that we would probably end up back at the default, which is that the officer could be disciplined, the officer could be fired. It should be something that other agencies should probably take into consideration, but it wouldn't be a basis for decertification if it did not fit within one of our definitions of serious misconduct. We wouldn't have the ability to take action against an officer if it didn't fit within the legislative or the regulatory definition of serious misconduct. I hope that, does that?
Yes,
Makes
that
sense.
answers it perfectly. Other questions or comments? Yes, Commissioner.
So I know when we had a lengthy discussion about this last time, I was in favor of our definition in red because of that exact argument. However, I think the definition that has been provided in blue has some very significant unintended consequences because it is so broad. And I would encourage us to step back from our previous conversation about if you're advising us that our language in red is not legally defendable, then we either now move to sticking with the initial legislative intent and not having an overarching definition. And if we get that one-off case, because we have to understand there is also a discipline process within agencies, and I know not every agency is diligent as others, but that then we, stay away from establishing an overarching definition and stick to the 9. Because I think that definition in blue to me, and interpreting it, is actually way broader. And I think what is going to come to the commission and the amount of workload that is going to come to post, this has significant unintended consequences and goes beyond the legislative intent of SB2. And so that's just my comment on it, is that if Toby doesn't think that what is in red is legally defendable, either we step back from that and go with none, or we have a different conversation about what it could be, but that's just my comment.
I just want to point out before Toby addresses it, and then I understand Commissioner Barcelona has something to say. The broadest definition of all is the one in red. The language in blue actually does narrow it in legally, because again, the definition in red is demonstrating any lack of fitness to serve as a peace officer. That's everything. Here, there is some delineation in the blue, but go ahead.
And so just to be clear, I'm not saying that the language in red is not defensible. And in fact, the language in red is, in my view, it is really just it's a recitation of language that the California courts would in any event apply to any license action that we took as a matter of constitutional law. So in other words, a court would say, before you're going to take away an officer's ability to practice their profession, it would need to be for conduct which demonstrated a lack of fitness to serve in that profession. So in some ways, that is simply a restatement of what the court would already say is a constitutional minimum anytime we were going to remove somebody's ability to practice the profession. The question is if we're going to use that same language in order to serve as an overarching definition, which is broader than the 9, we can certainly do that. And then I'm just saying, as a litigator, what we see are, the first case that we take against an officer that does not neatly fit within one of the 9, and we justify it under that definition, then it's a challenge that we'll have to face. And it'll go to a court, and the question will be, is that regulation sufficiently concrete to give notice to any reasonable person that the acts or omissions that they engaged in were such that it showed that they weren't fit to be a peace officer? And I think we could probably make that argument with a lot of the type of conduct that we are probably going to be looking at if it's so severe that we think it should remove that person's ability to practice the profession. So no, I am not at all saying that it is not defensible, the conduct, the language in red. Again, all I was trying to do is to see if there was some way that we could perhaps further clarify it so that it was clear to the field. I don't disagree with your comment that, for example, some of the language in there, for example, any conduct that would be unprofessional, unethical, unlawful, might be much broader, because you might have conduct which is unprofessional but does not necessarily demonstrate a lack of fitness. So again, I think the idea was, what I was hoping to do was just get this conversation going, right? We can certainly look at the language in blue if you want to go that way, and we can massage it and change it, or we can get rid of it altogether and just say serious misconduct is, and go in right into the 9, or we can just leave with the language in red. One comment that I did want to make, if we are going to stay with the language in red, and Jackie, I think we talked about this, OAL mentioned it with respect to one of the later regulations. We have a separate definition, right? We have a separate definition, Jackie, definitional reg.
Yes, that's correct.
Okay, so we really don't need to say serious if we're going to stick with the red, we don't really need to say, and probably shouldn't say, is defined as. We would just say serious misconduct is acts or omissions. See what I'm saying? So we would take out that is defined as, and it would just be serious misconduct is acts or omissions demonstrating a lack of fitness. So if we're going to stick with the red, I'd suggest we take out that, because it otherwise it looks like it's a definition, and we should put it in the definition section of the regulations. So other than that, yeah, we can either go with the red, we can massage the blue, or we can go with neither of them. It's just up to the commission.
Okay, before I call on Commissioner Barcelona, in a jury instruction, the comma would be or. So end experience would find to be unprofessional or unethical or unlawful as a matter of law. There, is it, as you've written it, all of those things or any one of those things?
Yeah, it would be any of them.
That's what I thought. Okay, so even though there is a comma, it does mean or. Okay, Commissioner Barcelona.
When this bill came about, a lot of us were involved in working with this bill and getting it to where it is, and the governor signing it. Now, here we are at the commission, and some want to become legislators and change it. And I don't think that's our job. This bill was signed by the governor the way it is, and we have the 9, and that's what we should work with. We're not legislators. And a lot of us worked really hard to get this bill to where it is and to get agreement on it. And it's painful to sit here and listen to people who now want to become legislators and change it. That's not our job. Let's give it a year with the cases and see if we have problems. And then after that year, we can take a look at where the problems were, and then we can make recommendations to amend the bill and do it appropriately. Because I think amending the bill back at the legislature is the way to fix it, rather than trying to become legislators here. That's not our job. Enough said.
Thank you for those comments, and I certainly appreciate them. This is a very unique situation, Commissioner Barcelona, and please, somebody correct me if I'm wrong. they said, here you go, Post. If you want to do more with this, go ahead and do it. Usually they just say, here is the law. So I think they were looking for something if we decide to embrace it. But I certainly appreciate all the work people.
Well,
put
I think
into
there
it.
might be some that do, but I can guarantee you the 120 that's over there.
Yeah.
You know, the 80 in the legislature and then the 40 in the Senate. I think they have a much different idea about it, and they probably would like to have some real say-so if things get changed. And I know there's lots of special interests
Mhm.
out there as well.
Yeah.
And I just don't think that we should be trying to be the legislature here. I think we should be trying to work with what the legislature passed. Many of us worked really hard to get this bill to where it is today, and I don't want to see it change. I'd like to work with what we have, and let's see how it works in the process with all the cases. And I think that at the end of the year, Manny is probably going to have some suggestions where we need to tweak. But I think we ought to do it appropriately, then go back to the legislature and say, here are our problems. We'd like to amend the bill, and here it is. But that's the appropriate way to do it, I think. I don't.
Okay, let me
think any of
suggest that
us-
we have more discussion, and then at the end of the discussion, if you want to make that motion, then we'll have a motion we
Sure.
can vote on.
Yeah.
Thank you. Any other questions or comments on this? Yes, Commissioner.
I'm leaning towards our original definition, in that I like that it's broader. I think it addresses Commissioner Ewell's concern for the one-off that might slide through, because it does kind of cover the general neglect of duty that doesn't fall under the other definitions, because serious misconduct includes, but is not limited to, the following. I do agree we should get rid of is defined, and Toby, if this mattered to add act or acts, omission or omissions, is it good to have the singular and the plural as has been added in your blue?
Yes, in fact, I thought we had made that. Oh, yes, I'm sorry. I made that change when I wrote the language in blue, because I thought it would be, you may have a single act.
Right.
Which is sufficiently serious. And if we leave it as in red, acts is plural, so I'd have to prove 2 acts or 2 omissions.
Right, and you will definitely get that peace officer that says, well, I only did the one thing.
So,
Plural.
I think that's a very good clarification, and that is, if you want to go with the red, I would suggest that not only do we take out defined as, but that we include my language in the first on the first line in blue. So it would say serious misconduct is an act or acts or an omission or omissions. And then we would go back to the red, demonstrating a lack of fitness to serve as a peace officer in California.
Anything else? Okay. Commissioner Brazil.
A couple quick things. One, I think this flowed better for us when we did the 9 first. And then came back to the overarching, because we identified some gaps that this was designed to cover. So I think maybe if we go through the 9 and then come back to this one, it might be beneficial.
Okay.
I still have concerns that we need to have something that an agency can push someone through that doesn't comply. And I gave the example before of an agency I work with that I know of. A public safety employee goes to a different country and commits what would be crimes in this country, but are legal there. That to me is unprofessional, but the 9 don't cover it. If an agency becomes aware of it. So that's my concerns. We look for the bigger gaps, not the nuanced ones. And maybe we change the language in the 9 that allows that example to come forward. Something that occurs in another jurisdiction that may not be a violation in this jurisdiction in the state of California, but it is somewhere else. That's extremely unethical. So my recommendation is we go through the 9, see what language changes are recommended there, and then come revisit this at the end to see if there's a gap that we need to close, or maybe there isn't. Maybe we've covered it all. Just a recommendation.
Thank you. Yes, Commissioner.
So, other than changing it to act or omissions, because I agree that there's going to be one thing that's so egregious and they're going to say, I didn't do it twice. So you can't, let me go. But I'm reading it. I'm a simple girl. So I'm reading the blue and I'm thinking, okay, what does that really say? Even as a chief, where I understand the red, and, I'm thinking is it, and I know Toby, you wrote it for the lawyers to understand it and the challenges and all this other stuff. But I'm thinking, is there gray areas in that blue that are going to be challenged if, it's determined that we should, suspend or terminate the certification, that they're just going to go through because there's more words and find more loopholes in the more words. So that's just my comments. Thank you.
As a lawyer, I would say, of course, there will be people who will fight the words. Of course there will. That's why,
That is what we do.
that is what we do. Yes, Commissioner O'Rourke.
My, just from my notes from our meeting last month, that is not even, in my opinion, that is not what we even came up with.
Okay.
Read.
Do you have your notes? Do you
I
want to
do.
read those?
And I
Okay.
thought it came down to serious misconduct includes but isn't limited to a violation of one or more of the 9 criteria might prompt a review to determine the eligibility of or revocation of a peace officer certification, determine if the officer is fit to serve as a peace officer in the state of California.
So there was no lack of fitness.
Right. I know we got caught up on the whole fitness and all that.
Okay.
So I'm, wondering, I know we made changes and all that, but if I think maybe we go back to the Dahlin doctrine and keep it simple and just not have an overarching theme. And there's your 9, you go through the 9. If they
Okay, perhaps Jackie or Maria or Manny can address the discrepancy between Commissioner O'Rourke's notes and that.
Yes, Madam Chair. So when we created these regulations, we did it off of the verbiage that was contained in the official transcript and the final identified definition as the commission voted on it that day. So this is based off of the official transcripts.
Yes, and if I may,
Please.
I do recall the conversation that we had about it, and one of the commissioners I know, because I had included language from the case law which talked about both fitness and competence. And so I had suggested that we use the language, a lack of fitness or competence to serve as a peace officer in California. And then somebody read I think it was Jackie, actually read the language from SB2, which uses the word fitness. And that was how we ended up taking out competence and including fitness in the definition. So that was my recollection of how we came up with the language in red. Having said that, though, these discussions, obviously, they're back and forth and, people can have different understandings. So I appreciate it.
Okay. Commissioner Donaldson. Hi,
Yes, ma'am.
how are you?
I'm doing well. Thank you.
Okay. I remember you had a litany going last time. You still remember that?
Yeah, I would be with Commissioner Brazil. Let's look at the overarching 9 items and come back to this at the end. I'm disappointed that our definition has turned into War and Peace.
It's War and Peace.
It's turned into War and Peace.
Thank you. Okay, Commissioner Salazar, did you have anything to report from the advisory committee on this? I mean, Chief Salazar.
Thank you, Madam Chair.
Yeah.
We received the same report yesterday. We didn't get too into the weeds on the definition of serious misconduct, but clearly the concern there from members of the advisory committee or from chiefs would be how to define that and how many definitions you will have of who determines what a lack of fitness is. So I think really kind of sticking to the 9 overarching principles that have been identified, not becoming, I don't know that you can come up with a complete definition. There's always going to be a different translation as to what a lack of fitness is going to be.
So because of that vagueness, the discussion, the advisory was stick with the black or the red.
As I mentioned, we didn't get too into the weeds on that in terms of these 2 definitions, so I can't speak on behalf of the entire advisory committee as to which definition they chose here.
Okay, thank you. Was there someone else with a comment? Yes, Commissioner Kelly.
Just one additional comment because he spurred my memory when he brought that up. We did have a lengthy discussion on lack of fitness.
Yes.
And I do think there are some concerns with using that term because we had a lengthy discussion on, fitness for duty and how that relates to what we currently do and the standards we currently have in place. I know that was a lengthy discussion and that is certainly still a concern if we were to, use the red. So I would agree that we should go back and look at the 9 and really maybe spend some time fleshing that out before we come back to the whether we use an overarching definition or not.
So there is, so of the 9, there were a few that needed to be looked at again. I want to be clear if the request from both of you is that we look at all of the 9 before we take a vote on this, or just the ones that were ambiguous? Commissioner Brazil, what was your thinking when you made that suggestion?
I suggest we go through all 9. If there's no language changes, we just references us back to it.
Okay,
And then in my mind, I'm going to start processing the one-offs to see if these major one-offs would fit in any one of these. And I may ask Toby, would potentially that fit? And I think we all might have one-offs in there that we want to make sure that we've covered either from our own personal experiences or we read about them in a newspaper article somewhere to see if they fit these decertification.
okay, Commissioner Gordon, was that your thinking as well?
Yeah, I would agree. And I would just also, as much as we want to make sure we include everything, just recognize the fact that this is new and we're not going to get every what if to fit at this moment.
Okay, let me just make a point that we have to, before we leave today, agree on what we're going to do. I see no problem with putting now the horse before the cart or after the cart, but we do have to come up with this decision today. Let me suggest now that we take a break and come back at 11:25. And at that point, we do pause in this process because enough of you has suggested it, that we move on to the other part, which is going through all 9. Is that going to work for you, Jackie? Wonderful. Okay, we'll see you in 7 minutes. Thank you, everyone. look back. And now, have you had time to arrange for that, Jackie, for us to start looking at the 9?
Yes, Madam Chair, we are
Excellent.
ready to move on.
Back to you.
Thank you very much. So we're going to go to the very first of the 9, which is the dishonesty component identified in statute. And as you can see by this color-coded text on the screen, that the information that the commission added to this is in red, which is dishonesty is a material, intentional, or willful act. So after a legal review, it was determined that this verbiage caused a narrowing of the legislative's command or the intent. And so if the commission chooses to expand on this definition, there is suggested language provided, but I will defer to Toby to give further legal clarification. Please, Toby, thank you.
Sure. So I think this may have come from OAL, but I don't disagree with it. And that is that the way that we did it in April is by adding material, intentional, or willful, inserting that into the legislative definition. We are limiting in some ways what the legislature has commanded that we have to have as a statutory or regulatory minimum. So the legislature has told us that we must take jurisdiction over dishonesty relating to the reporting, investigation, or prosecution of a crime. And we inserted that intentional, material, willful language into it. So the idea is that in doing that, we are improperly narrowing what the legislature has told us that we need to consider. So my thought was, and apologies to any of the commissioners, I'm not trying to be a super legislature or whatever. I'm just trying to give the commission choices here in terms of how to accomplish the same ends, but to do it in a way that hopefully will pass OAL scrutiny. And that is what we can do is we leave the legislative language intact. And that's what you'll see, the bottom part leaves the legislative language intact. But then what I tried to do is instead is said, okay, so this is the legislative language is there and we have jurisdiction in those instances. But then I came up with the language in blue as a way to try to say, in considering whether or not a revocation or suspension is proper, we will consider the extent to which the dishonesty related to a material or significant fact, et cetera. And so that's just a way to do what we did above, but to do it in a way that hopefully passes regulatory scrutiny. So that's what is going on there.
Thank you, Toby. Questions, comments?
I have a question for Toby.
Yes.
If we leave it in red, is it going to fail regulatory scrutiny?
Well, I can't tell you what would happen, but I think that it is quite likely that OAL would say that if we leave it that way, that we have improperly narrowed or changed the legislative command. In other words, the legislature didn't tell us material, intentional, or willful. That's something we've added. So my belief is that we need to, if we're going to repeat the language of the legislature, we need to leave that language intact. And then if we want to have the idea that, but we consider it important as to whether it's a material, intentional, or willful act, we can say that, but we should say it in a separate sentence. You don't have to be wedded to what I came up with in blue, of course.
Those are limiting terms, material, intentional, or willful. So I would expect they would not accept it. Other comments, thoughts? Does anybody, let me just try to shorten this. If we decided there was a motion, there could be a motion to leave the language as it is and remove is a material, intentional, willful act, the language we added, and just leave it as it was. Or we could add the language that Toby has eloquently attached or not. Or we could send it in the way we sent it in and let OAL say, you limited us and we don't want to go forward. Take that observation. So are there any comments or is there a motion?
I'll just get it out there. My motion is that it is just the 9, the way the bill is.
I'm sorry.
It is defined as the 9
Okay,
and leave it at that.
okay,
And I think that we have once this gets up and running the first of the year, we'll have time to look at where the problem areas are.
mhm,
And then executive director can compile those, and then we can take a look and see where we need to make tweaks.
okay. Commissioner Barcelona, let's take that one by one. So I think there's a motion now to leave the language as it was and remove the words "is a material, intentional, or willful act." Is there a second? Are there any comments or questions? Okay, are we taking votes en masse or individual on this one? I'm sorry.
Yes,
Mass.
Absolutely. It can be, you can ask for all in favor, all
Okay.
opposed, and then we'll, if we need to
Okay.
count, we can.
All in favor?
So, Madam Chair,
Yes.
just for us slow guys over here on the corner, can we just figure out what we're voting on? I
Sure.
understand the comments made by Commissioner Barcelona. Are we focused on this particular item that's on the screen?
Yes.
Okay, so the choices before us are to submit what we put together at our workshop
Yes.
and submit what's in blue, or finally submit what was there before we had the workshop.
Or a fourth, that you have some new and fabulous language that you personally would like to add to this.
I struggle with reading and writing.
But the motion we have before us now is the elimination of, is accepting the first paragraph with the elimination of what's written in red. There's been a first, there's been a second.
Well, hang on a second. My motion is serious misconduct is defined as, and then it's the 9, as the bill's written, nothing else. Is that where we're at?
Oh, you're now back on the definition?
Yeah, yeah, I
Okay,
just want it to be simple, back to what the bill is
Okay.
defined as the 9.
So
Yeah,
you're
I'm not
saying
interested
the
in what's
overall,
up there. I mean, I think that the bill, we already have the bill from the legislature signed by the governor. And my thing is let's stay with what we have with the 9.
okay, I appreciate that. So we'll take a step back. I thought what we were doing now was voting for each of the 9 individually because they were commissioners.
How are we voting for the 9 when they've already been, it's already in the bill and it's in law?
Because what happened at the last meeting is we added language. That language has been added to 1. There are a few that we didn't add any language to at all.
Okay.
I heard at least 2 commissioners say, I'd like to go back to the 9 so that I could make some decisions. I think the most efficient way to do that is to do each of the 9 individually. And then we can move back to the first one, which. was-
Then I'll withdraw my,
But do you have a motion about number 1?
I'll withdraw for now.
Okay, all right,
So we're going to go on each one
correct.
and we're going to either accept the way it is or we're going to change it. Is
Correct,
that my understanding?
yes.
Okay.
Annie? Yes,
Hi, just for clarification, Madam Chair, this was already previewed by the Office of Administrative Law, and we've already been advised it will not be accepted with this amended verbiage in red.
it would not be accepted.
That
That
is
was,
correct.
what I would think as an attorney.
Yes, thank you.
So we don't have to send it back with this language because they already indicated they will not accept those, 7 or 8 words there. Yes, Commissioner Brazil.
I have a kind of a procedural question. So we come up with our misconducts, then is there going to be any guidance or manual on how we interpret them later? My point being, can things like in the blue be part of our guiding principles? Do they need to be in this, go through the ledge analyst office, or can they be part of our process when we review them? Basically a manual of how we look at this section 1 that we need to take into consideration. Was it material? Was it intentional? Was it willful? When we make a decision on whether it's suspended or revoked.
Toby is going to speak on that, but in general, regulations are regulations and suggestions on what to consider is suggestions what to consider. What attorneys look at are regulations. And then they might look back to see what was in this case, the legislative intent, or in this case, the commission intent. Toby?
So I understand what you're saying, Commissioner, and it makes perfect sense. The problem is there's something in California called an underground regulation. And to the extent that the commission establishes effectively guidance as to a statutory or regulatory matter that would apply evenly to all matters coming before it from that point on, that is in effect a regulation. And so we can't put that in any sort of guidance document or informal memorandum document. So, but because it would run the risk of it being an underground regulation. So the better thing would be to, if you are going to have a rule of general application that's going to apply to all litigants coming forward, then it should be in regulation.
Okay. Regulation is a regulation, has to be there. Any other comments? Yes.
So my only comment would be is going back to when we had the original conversation about this particular one, we were concerned, and I think Commissioner Braun brought it up in terms of timesheets and things that were not necessarily material that without adding some language to it, that would be something that would be a decertification. So that being said, I would encourage us then to add the blue section that was suggested by Toby, because I think that addresses our concerns in terms of those type of incidents. It actually gives the commission and the board some room to have, I think, fruitful discussions on whether the material was in fact exactly that. So I would encourage us to actually use the blue, what Toby suggested, because of that type of, to make sure that we are considering all circumstances when we look at the case.
I understand. So are you making a motion?
Yes, let's make it a motion. Let's make it easy. I
Okay.
make a motion that we adopt one with the language added in blue.
Okay, is there a second? Okay, any discussion? Comments? All in favor?
Aye.
Oppose? Okay, 2 oppose and 3 oppose? Okay, could you raise your hand if you oppose, please? 1, 2, 3, 4 opposed, and now raise your hand if you, 1, 3, okay, 1, 2, 1, 2, 3, 4, 5 in favor. Okay, the motion carries. Yeah. Yeah, and I will vote to add the language. So we have 6. Okay. Thank you. Now on to 2.
Thank you.
Abuse of power.
Yes.
Now that, just so I understand it, OAL has already weighed in on this one as well and felt that knowing, abusing the power and authority of public office and the word knowingly again was rejected by OAL.
That's correct, ma'am.
Okay, so we're in exactly the same situation here. Would everyone take a minute to review this? And then let's see if there's a motion or discussion. Okay, so discussion, or is there a motion? Yes, Commissioner Yule. Let me try to do it as an attorney, and if not, everybody else can jump in. When you add, there's in law, there are acts that, strict liability acts, let's say, where it doesn't matter whether you knew about it or not. If you did it, you broke the law. It's not, so knowingly is actually narrowing the area, in this case, abuse. So we're narrowing it by saying knowingly abusing the powers and authority of public office. That's a narrowing of what it was before, which abuse of power is, including but not limited to. The same thing of adding knowingly again. So they feel the legislature has made their decisions. What's in black is the law. And by adding those words, we've actually narrowed. You want to add to that, Toby?
No, that is exactly correct. The idea is that the legislature has spoken, and what the legislature has told us are grounds for decertification we are stuck with. So when we narrow that language by saying, well, no, we will only look at an abuse of power if it follows this additional language that we've added into it, then we are narrowing what the legislature has commanded, which is broader. So again, what I tried to do is leave the legislative language intact, but then make clear that for purposes of that subsection, that we will consider these additional factors, and that will be a determination that the commission can make in terms of determining what action is appropriate or not based on those additional factors. One other thing I think we should keep in mind, and that is, Jackie, something else that we have on the agenda for later today is the separate regulation that has all of the factors that the commission can consider in determining under any given factual scenario whether or not revocation is appropriate or whether or not, in fact, it should be perhaps a suspension and not a revocation. And those are the multiple factors that we would always take into consideration, including things like what's the nature and extent of the offense, what's the officer's record and history, and that sort of thing. So we will always have that. The commission will always have that to look at as well. But again, the way I did it here, it's just some additional guidance. The legislative command stays intact, but we've made it clear as a commission that the commission will consider these other things that we consider that to be important. That's how I tried to walk the.
Commissioner Yule, makes sense. Thank you so much. Commissioner Barcelona.
I just wanted to make sure that we have can we have a roll call vote on all these so that the
Sure.
record records who's voting?
Sure.
The last one, how did that turn out? Is that just a unit? Was that
It was
just
6-4.
I know, but does the record reflect who voted how?
It does not
I think it
specifically do
should.
that. We can
Yeah,
certainly do
This is
that.
certainly, it's incredibly important. A lot of people worked really hard to get this bill where it is.
Okay,
So I'd like the record to reflect who's changing it, and who's not.
no problem.
Thank you.
So as to the first, let's get that first slide back up. We're going to revisit this temporarily. Say it again. Katie has it. Katie does have the information, so we don't need to go back. Thank you so much. We are on back to 2 now, the abuse of power. Anybody have any further comments, questions, or emotion?
Madam Chair, if
Yeah.
I may. Manny had mentioned to me that one thing that we want to make certain is clear in the record, and that is the extent to which what we're voting on is actually clear on the record. So Jackie, the information in the PowerPoint is in the agenda item, correct?
That's correct. Yes.
Okay, I'm just, the question is whether or not we should affirmatively read everything that the commission is voting on, but if it's in the agenda item, I think it's going to be sufficiently clear to all of us, so. Okay, sorry, just wanted, is that okay, Manny?
Thank you, Mr. Darden. Yeah, I just think if we change a word here or there, I think we should read it into
Yeah.
the transcript because we do refer to the transcripts. And also, obviously, this is your meeting, but I would suggest that we recite back on dishonesty, how the votes were, so we could put that into the transcript as opposed to our internal notes.
Okay.
If you don't have a
Sure.
problem with that, Katie can read who voted for and who
Sure.
voted against,
Okay.
or who was opposed and who was for.
Okay, can
that
we go
okay?
back to the first slide then, and we'll be super careful, and then we don't have to worry about it. Okay, so my memory, and then we are going to go back to so just to clear up the record, is that there was a 6-4 vote. And so therefore the 6 won, and the 6 was to add on the language in blue. Now I'll read the whole section, including the language in blue. Dishonesty relating to the reporting, investigation, or prosecution of a crime, or relating to the reporting of or investigation of misconduct by a peace officer or custodial officer, including but not limited to false statements, intentionally filing false reports, tampering with falsifying, destroying, or concealing evidence, perjury, and tampering with data recorded by a body-worn camera or other recording device for purposes of concealing misconduct. For purposes of this section, in considering whether a suspension or revocation of certification is proper, the commission will consider the extent to which the dishonesty related to a material or significant fact in the context of the statement or omission alleged to be dishonest, and will also consider whether the dishonesty appears to have been done willfully or intentionally with the intent to deceive. That's the language that passed the 6-4 vote. Manny, the record reflects who the 6-4 was. Would you like each person to vote to clarify the record even more?
I think we could just have Katie recite it. And if
Okay.
everybody feels that that is incorrect for the
Okay,
vote, then
so what we'll do is
correct the
Katie will
record.
recite it, and if anybody feels it's incorrect, I'll give you a minute to speak up. Okay, go ahead, Katie. Thank you.
Barcelona, no. Braun, yes. Brazil, yes. Donaldin, no. Doyle, yes. Dudley, yes. Ewell, no. Gordon, yes. Nieto, yes. O'Rourke, no.
There. So now that I have a better understanding of why the language was rejected, I'd like to change my vote.
Okay, and so that would be 7-3. Thank you so much, Commissioner Ewell. Anything else? Okay, now we're on abuse of power. Yes, Commissioner Brazil.
I just want to clarify, and I think Commissioner Yule kind of asked the correct question. At our last meeting, we had a long conversation about the so far number 1 and number 2. The language was proposed and then it was rejected because we're actually changing legislation, which we can't do.
Correct.
So staff came back with and crafted language, Toby did, that reflected the desires of the commission
Yes,
at that time. I just want to put that on the record. That's really what we're talking about is the staff did exactly what we asked them to do, got the feedback so we can keep the process moving.
I'm trying to save the commission's intent by coming up with an additional way to get the thought into the regulation without changing the statutory command.
Yeah, and our intent when we pushed it to you to go do that. With that, I move the language number 2 in blue. And do you want me to read it or do you want?
I can read it and then let me get a second.
Doyle second.
Okay, any further discussion? Okay, so the motion and what has been second is 2. I'm going to read it and then I'm going to ask each of you to vote individually. So we'll have a roll call vote. So the motion is to accept the language which is in the second paragraph as follows. Abuse of power, including but not limited to intimidating witnesses, knowingly obtaining false confession, and knowingly making a false arrest. For purposes of this subsection, in considering whether a suspension or revocation of certification is proper, the commission will consider the extent to which the abuse of power was a knowing abuse of the power and authority of a public officer. Would you please take a roll call vote? Office, thank you. So I'm going to read that last 5 words. And authority of a public office. Thank you. Now, would you please take a roll call vote?
Barcelona. Braun,
Yes.
Brazil,
Yes.
Donaldin. Doyle. Dudley,
Yes.
Ewell,
Yes.
Gordon,
Yes.
Nieto,
Yes.
O'Rourke. Thank you.
And the vote was,
7-4. Oh, sorry. Yes,
I'm sorry,
7-3. I'm sorry.
7-3. Okay, so it passes. Number 3, please. So there were no changes.
Correct.
Okay,
I'm
go
sorry,
ahead.
Madam Chair, for interrupting. Yes, there are no
Yay.
changes made to this either by the commission or through OAL. Thank you.
So there were no changes requested by the commission. And this is how it is originally written. So there is really nothing to vote on, but we're just for the purpose of being very careful, we're going to still do that. Is there a motion?
So move Doyle.
Is there a second? Any discussion? So the motion now is to stay with the language as it was originally written. Physical abuse, including but not limited to the excessive or unreasonable use of force. Can you please take a roll call vote?
Barcelona.
Yes.
Braun,
Yes.
Brazil,
Yes.
Donaldin,
Yes.
Doyle,
Yes.
Dudley,
Yes.
Ewell,
Yes.
Gordon,
Yes.
Nieto,
Yes.
O'Rourke.
Yes.
Thank you.
Okay, that carries with all yes votes. On to the 4th. Okay, take a moment to read this and then we can have some further discussion or a motion.
Perhaps I can give some context.
Sure, please.
Madam Chair. So this is, again, if there's a sword, I will fall on it. This is all me. So my thought was that instead of referring to, as the legislature did, the legislature said sexual assault as defined and described in Penal Code Section 832.7. My thought was that instead of referring to that section, that it might make more sense for us to simply take that very specific language and incorporate it within our definition. So you don't have to then be checking back and forth between sections. So you don't have to jump between our regulation and 832.7. We don't have to do that. We can certainly leave it as the legislature left it. So that was a suggestion. We can take it or leave it. The problem is, of course, down the road, the legislature might decide to change 832.7. And then the question is, if it does it also change 13.510.8, or will we have to come back and do a regulatory change? So what I did in blue is basically just took the language directly out of 832.7, and it is now just laid out in down below. Now, the one thing though, the difference is that the legislative language actually only included acts committed involving members of the public. So that's what the statutory language in 832.7 included, is only members of the public. What the commission wanted was to extend that to anyone, members of the law enforcement agency or members of the public. So the definition below removed the language with respect to committed amongst members of the public, and now includes any sexual assault whatsoever. So again, I probably have overcomplicated this. We can certainly go with number 4. That isn't a problem. The question is whether or not the commission would want to just specify the 832.7 so that it's all contained within the regulation, and we can really do it however the commission wants to do it.
So unlike the others where we further narrowed our definition, in this case, we, for lack of a better term, expanded it.
Correct.
And
that's okay.
has OA, that's what I wanted to get to. So we can expand it. And has OAL weighed in on this one at all, Jackie?
We did not have any comments from OAL specific to the added verbiage on this.
Okay, so unlike the other times we voted, OAL has not suggested that we can't keep number 4, the upper paragraph. But what Toby has done, instead of having people refer to 832.7, he put in the language of 832.7. So we could do the same thing. We could accept the first paragraph, accept the second paragraph, or do something else. And in this case, the do something else could be to add on the sentence that we added on before, and shall extend to acts committed amongst members of any law enforcement agency, to the lower paragraph written in blue. Yes, Commissioner.
I do have a question for Toby. Since it was written Penal Code Section 832.7, and you explained that could change, was the legislative intent there knowing that it could change? And so now we're narrowing it again, even though we expanded it, you're actually narrowing it if you can't change with that.
Yes, and that question could only be answered in the future if in fact Penal Code 832.7 changes. At that point, then we'd have to look and see what is the change. Was there also an amendment to 13.510.8, and we'd have to look back to see what the legislative intent was. Because it could create a legal question either way, right? Depending on what sort of change is made to 832.7 and whether or not there is or is not a change to 13.10.8. So, there certainly is an argument that as enacted, this language, the language that I've got in blue, is unquestionably the language that the legislature intended, because that is what currently exists. That is what 832.7 currently says. The question in the future, what is it going to mean if any of these sections are amended? It's going to depend on the amendment.
It's impossible for me to imagine that, because this happens all the time, where you take one penal code section and you add it to another, that they're oblivious to the fact that penal code sections can change. I would just add that to Toby's comment. And Commissioner Gordon, did you have a comment?
I do have a comment on the language in blue. I
Okay.
think we spent a considerable amount of time talking about amongst employees, and that's not always on duty. And so I actually do not like the language in blue at all because of that. And I would encourage us to stick with our original language and knowing, if there is a change to 832.7 by the legislator is clearly well thought out. It won't go without our notice and the impact that it has. So I would recommend we stick with our additional language, and I'll make a motion unless there's comments by any of the other commissioners.
I second that motion.
One moment. Did you have a comment?
Yeah, I have a question and seeking confirmation from Mr. Darden. So if we remove the reference to the penal code section, if that penal code section does change in any way, we will be required to change the regulation.
Correct.
Okay, I just wanted to get that.
Madam Chair, may I add something please to this? And while we're going over this, we just identified that the text in black is not exact as it was in the legislation. It should say sexual assault as described. So I would suggest if you want to go with that definition, we strike out the words is defined.
I understand. Okay. So we have a motion from Commissioner Gordon. Commissioner Gordon, do you want to amend? Let me read out what I believe your motion is. And did someone second that motion? Okay, let me read it again. Let's get a motion in a second if in fact this is the thought. The vote now is to vote to accept or not the following language as to 4. Sexual assault is defined as, excuse me, I'm going to say that again. The motion is to accept the language as I'm about to read. Sexual assault as described in subsection small b of Penal Code Section 832.7 and shall extend to acts committed amongst members of any law enforcement agency. That is the vote. Is that correct, Commissioner Gordon?
Yes, it is.
And the second came from?
My second holds.
Okay. So any questions or comments? Okay, let's take a roll call vote, please.
Barcelona. Ron,
Yes.
Brazil,
Yes.
Donaldin,
Yes.
Doyle,
Yes.
Dudley,
Yes.
Ewell,
Yes.
Gordon? Yes.
Nieto,
Yes.
O'Rourke.
Yes.
Okay, that motion carries. Was that 7-3 again?
It was 9-1.
I'm sorry.
9-1.
9-1. Okay, thank you. Is lunch here?
Yes, it is here.
Yes, okay. Lunch is here. It's 3 minutes after 12. How much time do you want for lunch, everybody? Okay, I heard 10 minutes from Tosoyevsky. Anybody else? So, okay, I'm gonna make that grow. Okay, so you just want to take 10 minutes to grab your food and come back. Okay, that would be then coming back at 12:15. Thank you. Commissioner Barcelona will join us. We were on number 5, whenever you're ready, Katie. Excuse me, Jackie.
Yes, thank you, Madam Chair. So number 5, the commission opted to add of actual or perceived in the red text on the screen, and we did not have any opposition to that from our legal review. Thank you.
Again, in this case, OAL said they would not accept the narrowing. Okay, is there a motion?
No, this was approved as is without a problem.
Yeah, this is okay because it's actually just adding. This is one of those situations where we're not narrowing, we're
Okay.
adding. So we're adding the perceived
Okay,
perception.
Do I
So-
move?
yes.
I thought you were waiting for a motion, Madam Chair.
I'm waiting for your motion.
I just said I'll move the item.
Second.
Thank you. Discussion? Okay, so just to be clear, the vote is on adding the words that we added. We can keep those. And so starting from the beginning on number 5, demonstrating bias on the basis of actual or perceived race, national origin, religion, gender identity or expression, housing status, sexual orientation, mental or physical disability, or other protected status in violation of law or department policy, or inconsistent with the peace officer's obligation to carry out their duties in a fair and unbiased manner. This paragraph does not limit an employee's rights under the First Amendment to the United States Constitution. Let's take a roll call, please.
Barcelona. Braun,
Yes.
Brazil,
Yes.
Donaldin,
Yes.
Doyle. Dudley,
Yes.
Yule,
Yes.
Gordon,
Yes.
Nieto,
Yes.
O'Rourke.
Okay, was that unanimous?
Yes.
Okay. On to 6.
Okay, Madam Chair, regarding number 6, the commission did not choose to expand on this definition any further. However, the legal review advises that we should remove the paragraph I have in blue, as it's not legally necessary to be placed into regulation. I was unable to do a strikeout on PowerPoint, so the blue text on this one is recommended to be removed.
Want to say something about this?
Jackie, so did that come from OAL, the removing the as determined by the commission? Because that's actually the statutory language, isn't it?
Yeah, so OAL said that they suggest, actually, I'll just give you the exact verbiage that OAL said on this. So as determined by the commission, it could be dropped because you would have done it, but if it means the commission makes the determinations on a case-by-case basis dependent on the facts, then the phrase shouldn't be dropped. However, it seems to lack any standards or guidance to be used by the commission going forward in deciding cases in a consistent and arbitrary way. So if we keep the determined by commission, then we're going to have to define what that means if we want to maintain that. If I explained that correctly.
Questions about this? Excuse me, any questions about this?
Madam Chair,
Yes.
so let me understand, number 6 at the top is what is word for word in the legislation. And it passed.
Yes.
And we reviewed it at our workshop, made no changes. And now the powers that be are suggesting that we go back and remove language from the original legislation, which we've been trying to avoid doing the whole time.
Toby?
Yeah, it kind of sounds like it, doesn't it? So my thought on this one was that I didn't have any issue with the idea of removing the collateral estoppel language. We've talked about that before, right? That probably was in there as a legislative matter, sort of incorrectly in that section anyway. And we have that collateral estoppel language. It exists in the statute, so we really don't need to repeat it in the regulation. So I would be okay with taking that out to the extent that the collateral estoppel confuses what is there, which is acts that violate the law and are sufficiently egregious or repeated. I didn't have the discussion with OAL. So, I mean, I suppose I see what the OAL attorney is saying, but Jackie, was he saying that they wouldn't approve it if we passed the language exactly as the legislature had recited it?
If we leave the as determined by commission, then it needs to be expanded upon. One suggestion could be is that we do have those factors to consider in
Yeah,
one of our.
that's what I was
proposed-
thinking, because we always, with every one of these, the commission's going to ultimately make the determination based on the facts as applied by the regulation or the statutory language, whether or not it warrants suspension or revocation. So it just seems like, I mean, yeah, I agree that having that language in there is, language that we will automatically do anyway, but it's difficult to see what OAL's problem is with that since it's directly from the statute.
Perhaps we could, and I'm just throwing out a suggestion, can we maintain as determined by the commission and reference the regulation that discusses the factors?
Yeah,
Perhaps.
but I think that we would do that, you would do that in the statement of reasons, right?
Yes, we can do that in the statement of reasons.
Right, so we don't have to put it in regulation, we just leave the language as the legislature had given us.
That's correct. We can do that as well.
And then in the statement of reasons, you can explain why we left legislative language in the
Yes.
regulation.
And reference that in the.
Yeah,
Correct.
okay.
Yes.
Madam Chair, can I make a motion to accept the top number 6? No amendments, not removing anything.
Yes, you can.
I'll second that.
Second?
Yes.
Okay, let me read it. What we are now voting on is accepting the legislation as it was initially written. And that is the upper paragraph, all in black. 6, acts that violate the law and are sufficiently egregious or repeated.
I'm sorry, Madam Chair. OAL specifically rejected the collateral estoppel. It will not go through the rulemaking process as is.
So did OAL give us the language in the second paragraph?
No, they just do not believe that this language needs to be in regulation. And they sent it back specifically saying it is not necessary and they would not accept it as it currently exists. Toby, you might want to help me on this. I'm not sure.
What will OAL accept?
Well, and the other thing, Jackie, is that as I understand it, I wasn't aware that you folks were talking to OAL in advance, which I'm glad that you are. But it's my understanding, though, that the OAL lawyers are basically willing to do sort of a preliminary look-see and to give you their thoughts. But even those preliminary thoughts are not necessarily binding and determinative, right? So ultimately, any language that we as the commission put through that language, even if it's language that we think OAL is approved of, we could send it to them and OAL could reject it. But having said that, I didn't see the communication from the OAL lawyer, but it does surprise me if the language is specifically in the statute that OAL is saying it would reject it if we put that exact same language in a regulation. So I don't know what to say other than I think that the following is true. And that is, if the statute exists, we can rely on it. We don't have to have a regulation that restates what is in the statute. So if we put this regulation through and OAL rejects it, I guess OAL can reject it. We still have the statute to rely on.
So for further clarification, Toby, we went back and forth multiple times with OAL on this and they repeatedly told us
Yeah,
that this section needs to be removed. So
okay.
that's just informational. So
Was that Jackie, this is Maria, was that a preference? Or was that a requirement? Or was that a recommendation?
stand by and let me look at our notes on this, if you don't mind.
Toby, can I ask a stupid question?
There's no such thing.
Okay, how can the OAL basically change the legislation? I know we've been looking at adding to it and some commissioners object to that.
Right.
How? Because that's a great position to be in. No, I'm just kidding.
Right.
How can they do that?
Yeah, so the idea behind OAL is that OAL is the master of the state regulations, right? Regulations are laws that are put in place by administrative bodies such as the commission. And OAL's job is to make sure that before we as a body enact a regulation which is put into law, which is put into California law, that it's consistent with statutory and regulatory principles and so forth. Again, I didn't have this discussion with the OAL lawyer, so and honestly, it kind of surprises me because I would think that we would have a very good argument that if it simply repeats the statutory language, that it should be more than sufficient if we just repeated that in a regulation. So I really can't speak for the OAL lawyer. Again, I do understand that the collateral estoppel reference, now there is a principle in legislative legislative jurisprudence, right? That you shouldn't have multiple subjects, right? That if you have a subject covered in a statute, it should just cover that subject and you shouldn't have multiple subjects within it. And it might be that they thought that the collateral estoppel reference was improperly here because, and to be honest with you, I agree, but it's what the legislature gave us, right? I think it's very clear that the legislature intended that collateral estoppel does not just apply to subsection 6, it applies to the entire act. And I think it was just mischaptered there, but you know, it is what it is. We have to deal with it. So it may very well be that that's what the OAL lawyer thought, but again, I just don't know. I don't think we're losing anything by removing the collateral estoppel language, but I understand fully the commissioners that just want to say, you know, that is what the legislature gave us. Let's not mess with it. I get that.
Toby had a follow-up, and you actually referenced it at the end. What does it mean to remove it for us?
It doesn't, honestly, it doesn't mean, in my view, it doesn't mean anything. Because again, it exists in the statute. So when it exists in the statute, we can use it and rely upon it. We don't need to have it in our regulation again. So if we take it out, it doesn't do anything. Again, sort of my view of all of this stuff is when the legislature enacted this Senate bill, it gave Post the power and the authority as a commission and as the expert in this area to further regulate, correct? So the commission can establish regulations that clarify the legislative mandates. If we take that out, it doesn't do anything to the statute. The statute still exists in that principle. Lawyers, trust me, lawyers will be arguing about what that means for the next couple of years. Whether it's in the regulation or not, it doesn't matter. It's in the statute. So we can take it out and it isn't a problem. Again, understanding the objections of we don't want to mess at all with any of the legislative language.
Jackie, did you do some further reading you wanted to share with us?
Yeah, so further research through my notes on this is that this doesn't do anything to expand on the definition of serious misconduct. It's more of a procedural point. If you do want to choose to keep it in the definition, we can. We just have to further support our justification on why it's there.
Yeah,
And that's what they have not been accepting is our justification that it's currently exists in penal code. They haven't accepted that justification. So we'll have to further figure out how to justify the existence of it if we maintain it.
Do you want to comment on your interpretation of what Jackie just said?
Right. So the idea is that I think that some of the objections of what I'm hearing from OAL is that to the extent that you are promulgating a regulation, you have to sufficiently describe it in what's it called? The ISOR, the statement of reasons, whatever it's called. The initial statement of reasons, right? So you have to just sufficiently describe for regulatory purposes what the reason is that you're doing it. And that can sometimes just involve wordsmithing, I think.
So at this point, there is a motion that Commissioner Donlin and Commissioner Donlin the motion was that we accept the first paragraph, the one in black, as it is written. Toby, do you want to comment on that? What the ramifications of that motion would be?
Yeah, again, I don't think I have anything to add other than what I've said just in the last however
Okay.
many minutes it is.
Okay.
Yeah.
And based upon what Jackie just told you, it doesn't change any of the other comments you made. Okay, so we have a first and a second. You still stand by your motion? Okay, and the second still stood by that. So now I will read the top paragraph, and thank you, Jackie and Toby. 6, the motion is that you accept paragraph as written. Acts that violate the law and are sufficiently egregious or repeated as to be inconsistent with the peace officer's obligation to uphold the law or respect the rights of members of the public as determined by the commission, whether a particular factual or legal determination in a prior appeal proceeding shall have preclusive effect in proceedings under this chapter shall be governed by the existing law of collateral estoppel. Would you please take a vote? Roll call.
Barcelona. Ron.
Yes.
Brazil.
Yes.
Donaldin.
Yes.
Doyle.
Yes.
Dudley.
Yes.
Yule.
Yes.
Gordon.
Yes.
Nieto.
Yes.
O'Rourke.
Yes.
Thank you.
And Manny, you have a question? Oh, the vote passes. Thank you. And I believe it was unanimous. Now, Manny?
I have a question for Jackie, a procedural question for OAL. And personally, I'm in agreement with what everybody just voted on, not that it matters, but when this goes to OAL, if they approve everything but this, will they kick the whole thing back to us? Are we submitting them individually 1 through 9, or is one big package? They kick this back and it kicks the whole thing back to us. That's the way I interpret it, correct?
Yes, the entire package would be kicked back.
Okay, thank you.
Does that change your thoughts?
No, it does not. I'm still, as Commissioner Doyle, I'm as confused as I'll get up as to how somebody can change the penal code, but that's me. No, right minds.
Okay, anything else on 6? We voted, oh, look, a long 7. There was no changes from the commission on this one?
Gratefully correct.
Okay. Okay, so,
Motion.
yes, to accept this, second.
Doyle.
Are you happy to read it? Go ahead, darling. Happy for me to read it. Here we go. Participation in a law enforcement gang. For the purpose of this paragraph, a law enforcement gang means a group of peace officers within a law enforcement agency who may identify themselves by a name and may be associated with an identifying symbol, including but not limited to matching tattoos, and to engage in a pattern of on-duty behavior that intentionally violates the law or fundamental principles of professional policing, including, but adopt, not limited to, excluding, harassing, or discriminating against any individual based on a protected category under federal or state anti-discrimination laws, engaging in or promoting conduct that violates the rights of other employees or members of the public, violating agency policy, the persistent practice of unlawful detention or use of excessive force in circumstances where it is known to be unjustified, falsifying police reports, fabricating or destroying evidence, targeting persons for enforcement based solely on protected characteristics of those persons, theft, unauthorized use of alcohol or drugs on duty, unlawful or unauthorized protection of other members from disciplinary actions, and retaliation against other officers who threaten or interfere with the activities of the group.
Madam Chair, if I may, I believe that there was the inadvertent placement of the word adopt in all capital letters.
I saw
into this
that.
paragraph, which does not belong there.
Okay.
Jackie, can you clarify, is it all correct according to the legislation except for the word adopt?
Everything is correct except for the word adopt. That needs to
Okay.
be removed.
So I want everybody to understand that I read that paragraph, but now in your voting, would you exclude the word adopt? Because I'm not reading it again. Yes, Commissioner Brazil.
Actually on our agenda, when you look at the packet, the language that's in there as peace officers who threaten instead of against other officers who threatened or interfere. It's peace officers. It's the last line, third word over, officers. The actual language in our packet has peace officers.
Jackie?
Let's look to 13.
Stand by, please.
Okay. Standing by.
Sorry, Jackie.
Okay, it appears that that is correct. So in addition to removing the word adopt,
Jackie, I'm sorry. Hold on. I'm looking at 13.5.10. You were talking about the last reference in the last clause, retaliation against other officers. Is that what you're talking about, Rick?
oh, yes, that
I'm looking at 13.5.10 and it doesn't say peace officer.
does not say peace officers. You're correct. In our language that we submitted, we added the word peace officers to be consistent with the additional, all of the other regulations we included.
Yeah, I think we need to be sure, we need to be clear if we are changing at all the language of the statute. So in other words, so what we're saying is that this language is correct and tracks the legislative language, the language on the screen, with the exception of the word adopt. Is that right, Jackie?
That is correct.
Commissioner Brazil, are you satisfied?
Yeah, I was just pointing out that our agenda packet has something different. So which one we're going after?
Thank you. So again,
That's just Jackie wanting to make sure at least we're reading the stuff that's there. We're paying attention. I understand.
so the vote is to accept what's presently on the screen with the exception of the word adopt in the middle of the paragraph. Please take a roll call vote.
Barcelona. Braun,
Yes.
Brazil,
Yes.
Donaldin,
Yes.
Doyle,
Yes.
Dudley,
Yes.
Yule,
Yes.
Yes.
Gordon,
Yes.
Nieto,
Yes.
O'Rourke.
Yes.
Thank you.
Okay, that's unanimous and that passes. 8, please. Okay, once again, and Jackie, tell me if this is correct, the commission had no changes to 8.
That is correct. Thank you.
Motion?
Well,
Nieto second.
Okay, the motion would then be to accept as it was written and as it is written on the screen above. Comments, discussion? I will now read it to you and then we'll take a roll call vote. 8, failure to cooperate with an investigation into potential police misconduct, including an investigation conducted pursuant to this chapter for purposes of this paragraph, the lawful exercise of rights granted under the United States Constitution, the California Constitution, or any other law shall not be considered a failure to cooperate. Roll call vote, please.
Barcelona. Braun,
Yes.
Brazil, Donaldin,
Yes.
Doyle,
yes.
Dudley,
Yes.
Yule,
Yes.
Gordon,
Yes.
Nieto,
Yes.
and O'Rourke.
Yes.
Okay, thank you. That vote passes. On to the 9th. Once again, Jackie confirming, it appears that the commission had no changes to 9 as well.
That is correct.
Okay, motion,
I motion to adopt what's on the screen.
second?
I'll second it.
Thank you. Okay, I'm now about to read 9 as was written. 9, failure to intercede when present and observing another officer using force that is clearly beyond that which is necessary as determined by an objectively reasonable officer under the circumstances, taken into account the possibility that other officers may have additional information regarding the threat posed by a subject. That is what you're voting on now. Roll call, please.
Barcelona. Braun,
Yes.
Brazil, Donaldin,
Yes.
Doyle,
Yes.
Dudley,
Yes.
Yule, Gordon, Nieto,
Yes.
O'Rourke.
Okay, that motion also passes. So now we're going to go back to the very beginning of our meeting and take a look at the first slide. Quick refresher, we could, there is no need to have an overarching definition. That would be in black. There's the red that we discussed last time, and there is the blue that was suggested by Toby. And then there was a fourth option of changing the language altogether. Let's start with the motion.
For a minute, could you put the black up just to refresh my memory?
There is nothing there. That's why the black is up. There is no overarching definition.
Well, I thought there was something. No?
No, it was, so if we were not going to have a definition and just going to rely on the 9 areas that are provided by the legislature, it would simply say serious misconduct is, and then we would jump into
Okay,
the
got it.
1, 2, 3, 4,
Yeah.
5, 6, 7, 8, 9.
So then the original would be serious misconduct is. Is there a motion?
I'll make the motion that overreaching definition as it is written in the bill in black.
Which is essentially would be serious
Yes,
misconduct
yeah,
is.
yes.
Okay, is there a
Uh,
second? Okay, now, I guess what we'll do then is take a vote. Because what's available to us, the motion that's been made, and second is that we not have an overarching definition. So let's vote on that motion and see where we are, and then see if we want to vote on anything else. So please take a roll call vote on eliminating any kind of overarching definition, immediately going with the concept that serious misconduct is, and then the 9 areas we just discussed.
Barcelona. Braun,
No.
Brazil,
No.
Donaldin,
Yes.
Doyle,
No.
Dudley,
Yes.
Yule,
No.
Gordon,
Yes.
Nieto,
No.
Work.
None?
None.
Yes.
Okay, I wasn't paying attention. Where are we?
5-5.
5-5?
Madam Chair, from, right, Nieto. From our last meeting, we had a very long discussion about this, about the creativeness of peace officers to do things that may not fall under the 9. And I think that's where we ended up with the overarching kind of a catch-all, just in case, due to the creativity of human beings.
Okay,
Red.
Yes, sir. The red, not limited to, so created a catch-all.
2 lawyers are going to talk, which is never. Okay, let me tell you where we both think we are. The vote was 5-5. That means it did not pass. So now we can make it, someone else can make another motion and we can see if that passes. If we can't agree, then it defaults to no overarching definition. So we can listen to arguments or suggestions from other people. We can make another suggestion. Commissioner Yule.
Madam Chair, I make the motion to accept the language in the red.
Okay, so no matter what you just voted on before, you can change your vote, or there isn't even a change of vote. The only thing that's available is this new motion that has been posed. It has not yet been seconded, that we accept what's in red.
Doyle
So,
second.
I'm sorry,
Doyle second.
Doyle second. Okay,
Can I ask a clarification on what is in
Sure.
red?
yes,
Since it is not exactly as the commission, in my recollection, came up with, is there a possibility that we can go back to that? Because there was concern about the terminology of lack of fitness. Or we just have the motion on the floor and then,
let's take the motion now, and then we can see if that doesn't pass. And if that doesn't pass, we can go back to it. We did, however, discuss some changes. So I'm going to, I got the changes. So I'm going to read it the way I understood you all spoke and Toby entered. And then that can pass. And if it does, it does. And if it doesn't, then we take the third motion, which is to go back to some other language. So where we are now, I believe, is the motion is to accept what's in the red, but I believe as amended based upon our discussions. So it's serious misconduct. So we're taking out is defined. So is defined.
Correct. Serious misconduct
Is.
is an act or acts.
Okay,
or
that's
an
right.
omission or omissions.
Okay, serious misconduct is an act or acts or omission or omissions demonstrating a lack of fitness to serve as a peace officer in the state of California. Serious misconduct includes, but is not limited to, the following. Stand by before we take a roll call vote. You look animated.
Jumpy. No, we're trying to pull the transcript itself to read
Okay.
the transcript back
Okay.
as to what exactly the wording was from April. Do we have that, Jackie? Is Michelle pulling it?
Yeah, she's
How much
pulling it
time
now.
do we need for that? Just a few minutes, or is she?
She needs it a moment, please.
Okay.
Okay, so we're going to take a 5-minute break. Right now, we have not taken a roll call on what I read to you because Commissioner Gordon mentioned she was interested in also hearing, which makes perfect sense, what we said initially. So let's take a 5-minute break and then we'll see if we can find that information. Thank you.
what the outcome was, Joyce?
Hmm?
Did you hear what the outcome was?
I can't even remember. You're on the deaf side.
Did you hear what the outcome was?
Yes.
No, that's not.
Okay, so as far as I understand, the outcome is that that is in fact the definition we all approved of. So there is a motion, there is a second, and it's the following language. Stand by. Okay. Is there any comments or questions about what has been determined now, which is that what is written in red is in fact what the commission agreed to at our last meeting? Okay, so there is a first and a second. I'm now going to read so we can take a vote. If we in fact decided to go with this alternative, that would be what is written in red. Serious misconduct is an act or acts or omission or omissions demonstrating a lack of fitness to serve as peace officer in the state of California. Serious misconduct includes, but is not limited to the following : and the 9 would then follow. Okay, would you please take a roll call vote on that?
Barcelona. Ron,
Yes.
Brazil,
Yes.
Donaldin,
Yes.
Doyle,
Yes.
Dudley,
Yes.
Yule, Gordon,
Yes.
Nieto,
Yes.
O'Rourke.
Yes.
9-1.
Okay, so that has passed. And that is what we have. We have an overarching definition and we have the one that's written in red that I articulated. Okay, so I'm going to need a little help as to where we are on the agenda. We've now completed our votes on overarching definition. We have completed looking at the 9. So what are we up to? I see Andrew Mendoza up there, so we're up to good things.
Yes, Madam Chair. So we would like to continue with the agenda at item A, which will be a report on our amendment to Commission Regulation 1953. And law enforcement consultant Andrew Mendonça will present this for you. Thank you.
Have a script, because it would help Manny and I if I knew what page you're referring me to now of our script. Page 3. There? No. There, okay. Perfect, because Andrew's name is there. Thank you. We will now jump back to the beginning of the regular agenda. Item A is a report on amendments to Commission Regulation 1953. At this time, I will call upon law enforcement consultant Andrew Mendoza and Bureau Chief Jackie Nelson, SB2 transition team, to provide us a report on this item.
Thank you, Madam Chair.
Thank you.
Good afternoon. Andrew Mendonça. I'm a law enforcement consultant in SB2. Just to kind of ground us, Post Regulation 1953 is a regulation that deals with all of the elements that are required in a background packet that's done prior to appointment. Post staff are recommending 2 changes. One is just some cleanup language relative to we require that you either use the post personal history statement, or agencies are free to use their own. This is just some cleanup that adds that if agencies use their own personal history statement, that they include some information about disqualifiers under Government Code 1029. The second recommendation is to include what's called a verification of qualification for peace officer appointment. This is a new addition that came about because not often, but certainly sometimes during audits, we find that the packages haven't been thoroughly vetted or reviewed prior to appointment. So when we go out and we do audits, sometimes we find that items are missing. This is just an attempt to close that door a little bit and require some designee within the agency to go through the entire background package and make sure that it's complete prior to appointment. And with that, I'm happy to answer any questions about the proposed changes.
Any questions or comments?
Madam Chair,
Please.
I'd actually thank you for your report and make a motion to accept both those recommendations as regulatory changes.
Is there a second?
I second that motion.
Okay, all in favor?
Aye.
Aye.
Oppose? That motion passes. Do we now go on to item B? Oh, good. Item B is a report on amendments to commission regulations and 1003 and 1012. At this time, I will call upon Staff Services Manager Michelle Wheeler and Staff Services Manager Anita Finner, SB2 Transition Team, to provide us a report on this item.
Thank you, ma'am. Good afternoon, Commission members. In reference to Regulation 1003, specifically employment status notifications. And again, I'm sorry, my name is Anita Finner, Staff Services Manager with the Transition Team. Following a thorough review of Senate Bill 2, updates regarding the notification processes to post of peace officer appointments, separations, reinstatements, and disqualifications were necessary. The bill requires each agency to execute an affidavit of separation form adopted by the commission describing the reason for separation of employment as a peace officer and signed under penalty of perjury. This requirement has caused the current post form 2-114 titled Notice of Appointment / Termination to split into two separate forms, one being the affidavit of separation form when a peace officer separates from employment as a peace officer, and the second, the attestation of peace officer eligibility form for a new appointment as a peace officer. The creation of these two forms will cause the current form 2-114 to be repealed effective January 1st, 2023. This commission has been provided those three forms: the proposed repeal form 2-114 and the newly proposed attestation of peace officer eligibility and affidavit of separation forms to adopt, both which will be accepted electronically as an uploaded attachment when completing a notice of appointment or separation via the electronic data interchange, also known as EDI. The affidavit of separation form has actually been out for a 45-day comment period, and since then we've noticed a correction is necessary, which would require a second motion by the commission. Specifically, I'll be referring to the affidavit of separation, post form 2-357, correction. No, that is correct. Post form 2-357, specifically the third bullet under instructions, currently reads, upload a printout of this notice to the above address within 10 days of separation. We would like to recommend replacing two words above address with electronic data interchange with EDI in parentheses, so that the affidavit of separation will then read, upload a printout of this notice to the electronic data interchange within 10 days of separation. Continuing, to align with Penal Code Section 13510.1, proposed verbiage has been added to reflect that a notice of appointment shall be made to post within 10 days of appointment as a peace officer. Currently, Regulation 1003 allows 30 days. To align with Penal Code Section 13510.9, proposed verbiage has been added to reflect the affidavit of separation signed under penalty of perjury shall be made to post within 10 days of separation as a peace officer. Currently, this regulation allows 30 days. Additionally, language was also amended to remove the ability to make a telephonic request for a correction to a peace officer's employment record when incorrect information is submitted via EDI. All notifications and requests for corrections to a peace officer's record shall be submitted to post in writing and within 10 days, indicating justification for the correction to the record. Currently, this regulation allows 14 days. Regarding reinstatement notifications, proposed verbiage has been added to reflect notifications to post shall be in writing within 10 days of the change in personnel action. Currently, this regulation allows 30 days. Proposed verbiage has also been added to disqualification notification requirements to reflect notifications to post shall be in writing within 10 days of the final disposition. Currently, this regulation allows 30 days. Lastly, clarifying language was added to allow law enforcement agencies the ability to submit support documentation of a peace officer's disqualification from employment using other available means such as a fax or electronic submission in addition to mail. I can take any questions at this time.
Thank you. Are there any questions? Yes, Commissioner Gordon.
Just a quick question, since we are in the year 2022. It says upload a printout of this notice to the above address. Does this allow for electronic signatures so that that can be done? Because it does make a difference for a lot of agencies who have gone to that format to allow for electronic signatures.
Thank you for your question, ma'am. The affidavit of separation is signed under penalty of perjury and wet signature only.
Okay, thank you.
Thank you.
You're welcome, ma'am. Any other questions?
Yes, Commissioner Brazil.
Two quick questions. Do all agencies that are, have to comply with the law, do they all have access to EDI?
So we are in the process, Jackie, can you help me with that one? So please.
Yes. So obviously the agencies that currently are post-participating have access. We are in the process of entering those that are non-post participating to get access to our EDI roster since, or our EDI, since they are going to have to be subject to the mandates of SB2. So yes, everyone will have access.
Thank you.
They don't now, but they will.
Correct. We are working.
That was like,
that
that was an easy
direction.
one, right? It was a softball.
you.
Second question is, who's allowed to attest to the separation? Do we say it has to be department head, or is there any regulation on who actually is attesting under penalty of perjury?
So we have on the form specific as we have just I believe the agency head.
Yeah, I think it's the agency head or their designee, but it needs to be obviously someone of the hiring authority that has the authority to sign on that.
Yeah, I have a little concern on that one, just to make sure that we're really clear on who has to attest to it, because there will be, I worked with an agency in another state where a chief attested falsely and perjured himself. So I want to make sure that we are training the people that are signing it, and given that perjury will put them in the process for decertification, that we figure out who actually has the authority to sign. I'm just concerned we have a designee and some sergeant in some huge organization signing them because he's just signing the paperwork and not really knowing the background on the actual IA case or things like that. And I don't have a recommendation or solution for it. I just kind of open that up.
And the way I read it when I'm looking at the form, it actually doesn't say agency head or designee. It just says attestation of reporting official. So like my training manager, because he has access to EDI, technically, the way it reads now, could sign that. Like if we just notified him that this individual had been terminated or separated, you know, because that's who does that removal at this point, unless we provide some clarification, they may think they can continue to do it the way they've been doing it.
Commissioner, if the commission has a specific individual or list of individuals that they want to specify, we can amend the text to be very specific as to who is going to be attesting to this.
So my recommendation is that we make the statement, it should be specifically on the form, the agency's head or designee appointed by the agency head, because it's not realistic that, you know, the sheriff is going to be able to do, you know, or the chief of LAPD is going to do all 9,000, but I think it should be specific that it should be a designee made by the agency head.
I have a question for our staff from a regulatory process procedure. So if it is agency head or designee, how do we capture the designee, and does that need to be in some form of regulation? So for instance, at Los Angeles Police Department, they're going to have a, you know, bazillion people. How do we know who the designee is, and how do we capture that? Is there some other form that might be necessary? How do we do that, I guess, is a question.
Commissioner Nieto, I have a question. When you go into the EDI though, when you sign up, the head already has to give permission who can go into the EDI. Isn't that correct? So They are their designees. But I do understand how Commissioner Brazil talked about the perjury, but there is a process for the whole EDI system before any of these forms go in.
So will there be a process in EDI? And I ask because I don't know. I should know, but I don't. Obviously EDI, there's granting permissions for different aspects of EDI. So will there be a granting permission for the attestation of separation? Or the notice of appointment, or the notice of appointment as we're referring it?
Because this has to be a wet signature, so it's a little different.
Yeah, so I guess the best way to answer that, Manny, is I think it's kind of twofold. So if I'm understanding what I'm hearing correctly, that we would like to add the agency head or their designee to both the form and the regulation for clarification. And then how do we confirm the designee by the agency? I guess this is going to be a philosophical question for this commission. How far do we want to regulate the agencies to make those decisions? I don't know. I think that that's something that this commission should discuss and decide.
Can it be, again, this is a question, can it be simply whoever is granted permission in EDI to enter, the old notice of appointment and termination data? Can it be that individual who is considered the designee if it's granted by the agency? Don't know.
So if I'm understanding you right, you're asking if we can rely on either the agency head or as their designee, the person that is in EDI designated the authority to enter the notice of appointment.
Correct.
I don't believe that would be an issue, but we can confirm that with CSB to make sure that that's not going to be a problem.
It used to be in the past that when individuals were putting in for certificates, advanced supervisory, that we had to have the signature on file with us down in certificates. And then the certificate unit would actually verify that certificate, the signature to what we have on file. And that was something that they had to maintain. If we're asking them we want a wet signature and they have to mail this in or upload it with a wet signature, how can we replicate that? How can we replicate that versus having a wet signature is under the penalty of perjury? Anybody in there who's doing the NOAT has to have that responsibility and that ability to do that. It seems to me that we could probably streamline this a little bit better.
The EDI
process.
forms need to be signed. The application forms for EDI need to be signed by the agency designee and the person. This is going to get complicated. The person who's applying for access to EDI, as well as the individual at the agency who has the authority to grant them permissions to EDI. So we could use that, or we could go back to signature cards to verify. But we haven't used signature cards in a while, so.
Yeah, it seems counterintuitive. It seems that what you just said before, if we already have that information on file and we're granting them access, or the agency has granted them access to do the notice of terminations and appointments, that would suffice.
I believe we could do that.
So let me just make sure I'm hearing this correctly. So through the current EDI process, if I as agency head approve, because I have to give my approval on that to have access to EDI, then I'm also would be approving for them to submit this form on my behalf. Or do we need to make a clarification within it? Do we want to have a separate, where I designate that on that same form that I give permission? Does it have to be designated, or it can just be one and the same?
When it comes to something like this, I would think that you would want to have specific rights or give individuals specific rights, just to make sure that you know who's going to be signing these things, not just for a certificate,
Right.
but for an NOAT that is going to possibly end up here in front of you, I think that needs to have some further scrutiny from the agency head.
Right, which is my point. I want to make sure that if we add it to the process, which would be a good recommendation to add it to the current process, but as an additional step in the current process where we do that in the current process, but as an additional step.
I would agree with that.
So just to clarify, Commissioner Warden, right now, the application form is for NOAT, Notice of Appointment and Termination, and we would have to update that as well. Are you asking for a separate designation? So you would have to request access for Notice of Appointment and then a separate line to request access to be able to attest to the affidavit of separation. Not one and the same, but two separate.
Yes.
Okay.
Someone entering an appointment is much different than someone entering this information in terms of termination or separation. So I would recommend that it has to be separate.
Yeah, I would support that. We can satisfy your suggestions through coding through EDI. I think we could probably make that happen internally without needing to be more specific in regulation, other than adding agency head or designee to both the regulation and to the form, if that is sufficient for you.
Yes.
So to clarify, so we would address the form now, and then behind the scenes, we will address EDI and perhaps brief you at the next meeting as to how we're going to police that, so to speak, in terms of who is delegated and how we know who that individual is for the separation specifically. Is that reasonable?
For me, yes.
I do have one other comment since the microphone's still on for Commissioner Brazil. So Jackie and the rest of the team have already have attempted, at least sent out letters to the non-participating agencies to get them kind of enrolled, so to speak, into the process. Obviously, we don't know what we don't know, but we did send out letters. I don't know how many, 30 to 50 letters to all the different agencies to start establishing that interaction.
Okay, so the question in my mind now is, what is the staff recommendation on B?
So the staff recommendation for this would be to modify the existing text and regulation to add the verbiage agency head or designee, and to also add that verbiage to the form that we're proposing be adopted pursuant to this. And then we will work out the details in the back end on the coding within our systems internally. And just one more point, Madam Chair, that since this is part of a package, we have to vote the other secondary regulation as well before we make a vote on this.
Okay, so let me just find out, did the advisory committee have any comments on this item?
Madam Chair, there were no additional comments on this.
Okay. Tell me what you mean by that we have to vote the package, because I think we're at B. We voted A, now we're at B. And the question I would normally have is there a motion?
Yep.
To approve the changes as described in the staff report? That's the question I would normally ask now. Did you have something to add to that, Jackie?
Yes, please. So we just covered proposed or amended regulation 1003, and we have not discussed the amendment to 1012 yet. So we'd like to do our presentation on that
Please.
prior to the motion.
Okay,
Thank
so
you.
then the motion, so we haven't made a decision yet, or even sought a motion on that. We're waiting to hear about 1012.
Correct. Most of these are going to be in packages.
Okay, that's fine. Go ahead.
Thank you. Anita Finner, continuing in reference to Regulation 1012, conditions for continuing employment. To align with Penal Code Section 13510.1 amendments, proposed verbiage has been added to require peace officers who do not currently possess or will not be eligible to possess a basic certificate to obtain a proof of eligibility within 10 days of appointment. In addition, to align with changes to Penal Code Section 13510.1, proposed verbiage has been added, which will require every peace officer to possess and maintain a valid valid proof of eligibility until such time they are issued a basic certificate by post or they separate from service with the employing agency. Thank you. I can take any questions at this time.
Any questions about that? So I will ask, is there a motion to approve the modified proposed changes to post 2-357 affidavit of separation forms as described in the staff reports?
Make a motion.
Is there a second?
Second.
Okay, all in favor? Aye. Opposed? Okay, that motion passes. Thank you both very much.
Thank you.
Yeah, I was gonna say the same thing. Was that,
You add both of those in there.
was that vote sufficient to cover everything that you described in the staff report?
Katie is saying no. Can you, or Maria?
Yeah, I thought it was more.
I think we only did a motion for the form. We didn't do a motion for the report.
The motion was for, as described in the staff report. That's what passed.
Was that the motion? I thought the motion was for the form. I don't know.
Maybe we should bifurcate the motions then to make it cleaner.
Okay, so what I asked was, is there a motion to approve the modified proposed changes to post 2-357 affidavit of separation form as described in the staff report?
Correct.
That's what I asked. There was a first and a second, and everyone voted yes.
So I think the second motion, Madam Chair, would be to adopt the amendments to the text to the regulation.
Okay, okay.
Madam Chair, I move to
Okay.
adopt the amendments to 1003 and 1002 as provided by staff.
Okay, is there,
I'm sorry, 1012, correction, 1012.
hang on one second. Are you good with that? Marie? Okay, is there any questions, discussion? All in favor?
Aye.
Okay, that also passes. Is it time to move on to item C? Okay. Item C is a report on amendments to Commission Regulation 1015. At this time, I will call upon Staff Services Manager Michelle Whaler and Staff Services Manager Anita Finner, SB2 Transition Team, to provide us a report on this item.
Thank you, ma'am.
You're back.
I'm back. Anita Finner.
Thank you.
Thank you. In reference to Commission Regulation 1015 reimbursements for training, in order to comply with the new requirements of Senate Bill 2, it has been proposed to repeal Post Form 2-114 titled Notice of Appointment/Termination, as it will no longer be applicable beginning January 1st, 2023. Currently, Commission Regulation 1015 includes reference to the said form. Therefore, it is necessary to remove the reference in the regulation language. To increase efficiency in processing and ensure notice of appointments are made within the time frame required, which is 10 days, pursuant to Penal Code Section 13510.9, it is necessary to update the language to reflect that all notice of appointments will be submitted to Post via the EDI rather than by mail. Post will no longer accept a notice of appointment by mail. Peace officers must be appointed through EDI to be eligible for training reimbursement. I can take any questions at this time.
Are there any questions? Did the advisory committee have anything to say about this?
Madam Chair, no comments on this item.
Okay. Is there a motion to approve the changes that described in the staff report?
So moved, Braun.
Second Doyle.
Okay. All in favor? Aye.
Aye.
Opposed? None. Motion passes. Okay, now we're going to move on to item D. Item D is a report on amendments to Commission Regulation 1007, 1010, 1011, and adopt Commission Regulation 1202. At this time, we will call upon the same folks to provide us a report on this item. Please go ahead.
Good afternoon, Michelle Weiler, Staff Services Manager. So the first item I'm going to be speaking to is the proposed amendments to Commission Regulation 1007, Reserve Officer Minimum Training Standards. So the amendments here would be to add a requirement that all reserve peace officers minimally possess a valid proof of eligibility. So as we know, not all reserve officers possess a basic certificate. So those that do not would be required to possess a proof of eligibility. Then we would add the requirement that any law enforcement agency appointing a reserve peace officer who does not already possess a basic certificate shall apply for the proof of eligibility within 10 days of appointment. The process that we've built in is that this would happen simultaneous to the notice of appointment. And then the final amendment is to add a requirement that a reserve peace officer who does not currently possess a basic certificate must possess a separate proof of eligibility for each agency to which they are appointed. So, for example, an individual may be a reserve peace officer for the Los Angeles Police Department, the Los Angeles County Sheriff's Office, and maybe Pasadena PD. They would need to have a valid proof of eligibility with each agency that they are appointed. Okay, any questions on that?
That's where we're getting, any questions on that? Did the advisory committee have any comments on this item?
No additional comments.
Is there a motion to approve the changes as described in the staff report?
Nieto, I move to amend regulation 1007, 1010, 1011, and adopt the commission regulation 1202.
Actually, I only provided the amendments to 1007. I was going to go through each one separately.
All right, then I move to adopt the amendments to 1007.
Is there a second?
A second.
Any further discussion? Okay. All in favor?
Aye.
Opposed? Hearing nothing, the motion passes. Now moving on to item E. Item E is a report on amendments to Commission Regulations 1001.
We're still on D. right?
Oh,
Yeah, there's
So
still
bifurcated it,
more.
Madam Chair. Yeah.
I got lost.
Sorry. I wanted to allot time for questions after each.
Oh.
She has to do these.
We have to do them all separately?
Well, I think we were initially doing them all together, and I think
Yeah.
that was causing some confusion. So we're doing them separately, one right after the other, correct?
I'm going to suggest, at
No,
this point, can we just vote to include them all? Toby?
Yes, you can. Commission can do that. if they want.
I was
Wants
actually,
to hear all of them.
Okay.
yeah, I was pausing after each one in case there were questions on each regulation, but I can go through the rest of them all together.
Great.
Okay.
Why don't you take us all the way through 1202?
Okay, so the amendments to Commission Regulation 1010, participation is just a change from using the term department to agency to be consistent with the language that's used in SB2. And it also adding the requirement that any agency participating in the PROS program shall require that every peace officer appointed on or after January 1st, 2022, who is not eligible or already in possession of a basic certificate is required to acquire a proof of eligibility. Then the amendments, the proposed amendments to Commission Regulation 1011, which is twofold. Right now, it's professional certificates, or actually, I'm sorry, it's just certificates. We are proposing to remove the language related specifically to peace officer certification and professional certificates for peace officers. This would leave just the requirements related to professional certificates for public safety dispatchers and record supervisors. And as such, we are also proposing to rename as professional certificates for public safety dispatchers and record supervisors to more accurately reflect the content of this regulation. And finally, we are proposing new regulation 1202 as peace officer certificates, also under a new article, peace officer certification. So 1202 would be very specific to the requirements for peace officer certification and professional certificates. And this would include the language that was removed from 1011. So we're bifurcating peace officers from the dispatchers and the record supervisors. Now I'm done.
Thank you. Are there any questions? Did the advisory committee have any comments on these items?
Madam Chair, not on these items, no additional comments.
Thank you. Is there a motion to approve the changes as described in the staff report as to the amendments, regulation 1007, 1010, and also adopt Commission Regulation 1202.
Madam Chair, I am moving to amend, because we already voted on 1007.
Right,
Moving
that's
to
okay. We're putting them
amend.
all together, though. It's okay to do that.
Toby, is that okay to take a second vote?
I think since we already voted on 1007,
Yeah.
so I think it's okay to just do,
Making a motion to amend 1010, 1011, and adopt 1202.
Okay, that's fine. Okay, any questions? All in favor?
Aye.
Oppose? That motion passes. On to item F. Item F is a report on amendments to Commission Regulations 1001. That would be E. 1001 and Adoption Commission Regulation 1201, and that's item E in the report. At this time, I'll call upon Jackie Nelson, SB2 Transition Team, to provide us report on these items.
Thank you, Madam Chair. So after a thorough review of SB2, staff determined it was necessary to amend Commission Regulation 1001 definitions and adopt Commission Regulation 1201. So it was determined that there is a need to create a new series of regulations categorized under newly created Article 4, Peace Officer Certification. This allows for all regulations related to the certification of peace officers to be housed in one section and adds clarity and ease of use when post staff, the regulated public, or other members of the public seek guidance related to peace officer certification. Specific terms were removed from Commission Regulation 1001 and relocated to the proposed Commission Regulation 1201, which defines the additional terms specific to peace officer certification. So post staff reevaluated the regulation, and with the with the concurrence of the Office of Administrative Law, decided to keep the following definitions in both regulations. In both 1001 and 1201 for clarity purposes, since they will be used in both articles, Article 1 and Article 4. Those four terms that will be duplicated are executive position, first line supervisory position, middle management position, and quasi supervisory position. So if the commission concurs that the appropriate action would be a motion to approve the amendment to Regulation 1001 and adopt the proposed regulation in 1201. And then if it approves on that motion and concurs, it would be appropriate to make a motion to approve the amendment to the modified text in 1001. So that since we changed it after we put it out, we're looking for two motions on this. If that makes sense. Anyway, questions if you have any. Thank you.
So are you suggesting that that should the commission have a motion, it would be as to 1001 and the adoption of Commission Regulation 1201? Okay, are there any questions? Did the advisory committee have any comments?
Madam Chair, on item E, no additional comments.
Thank you. Is there a motion to approve the changes as described in the staff report? Second?
Second.
All in favor? Okay. Is there a motion to approve the modified proposed changes to Commission Regulation 1001 as described in the staff report? Second?
Ron?
All in favor? Okay, those motion passes. What?
You should ask if there's any opposed.
Any opposed? That motion passes. Thank you. Appreciate it. Okay, we're on G. Thank you both very much. A lot of work. Item G is a report on the adoption of Commission Regulations 1203, 1204, 1206, 1207, 1208, 1209, and 1210. At this time, I will call upon Law Enforcement Consultant Andrew Mendonca and Bureau Chief Jackie Nelson, SB2 Transition Team, to provide us a report on this item.
Hi, good afternoon. Andrew Mendonca, SB2 Transition Team. Regulation 1203 simply codifies the relationship between Government Code Section 1029 and 13510.8, which requires the commission to decertify officers if they've become disqualified due to one of the prohibitions under Government Code Section 1029.
Thank
Happy
you.
to answer any questions.
Any questions? Do the advisory committee have any comments on this item?
But on 1203 specifically, just discussion in terms of process and procedures, particularly related to the SAD division and post, and questions about that have mostly been addressed through concerns about recruitment, timeframe, process, and so on, not specifically to the regulation.
Is there anything you'd like the commission to consider based upon that meeting?
Nothing, I think those have all been addressed by staff.
Thank you. Is there a motion to approve the changes as described in the staff report? Second? All in favor?
Aye.
Opposed? Okay. That motion passes. Is there a motion to approve the modified proposed changes to the Commission Regulation 1206 as described in the staff report?
Madam Chair, we haven't had the presentation on 1206 yet. We just did 1203. And there
We have
is,
so much faith in you.
I know,
So now I'm going to ask for a presentation on 1206, please.
and we still need 1204.
1204.
So if we could take these individually, I think that will make it a lot easier. So that was on 1203. If you'd like to take a motion specific to 1203.
So is there a presentation on 1203, 1204, 1206, 1207, 1208, 1209, and 1210?
That is correct.
I will wait.
Okay,
for it.
very good. Thank you. Then we'll go
Thank
to
you.
1204 presentation,
Okay,
please.
we're now ready for 1204.
All right, 1204. This is a regulation, new regulation that allows for the removal from a post-agency roster of somebody if it's subsequently discovered during an audit that the person did not meet the minimum hiring selection standards. And I'm happy to go into that in more detail if there's any concerns about that. I know we've had some questions come up with respect to. This is only about removing the person from the post roster, has nothing to do with their employment within the agency. It's just a mechanism by which, because of some of the other regulations you've heard, that at the time of appointment, a proof of eligibility is being issued based on an attestation that the background was complete, that they met the minimum hiring and selection standards. This is just a mechanism by which we could reverse that if necessary. There's a number of due process steps built in before that would actually occur, up to and including presentation before the commission, but it essentially codifies that process.
Just a quick question and kind of a clarification in terms of process point. So if we hire, appoint, complete the form, they are in the academy and our annual audit comes up and our post representative comes in and says, we think there's an issue. At that point, then you would do what? What does that process at that moment look like?
Of course,
That's my
yeah.
point. Do what at that moment?
Yeah, I mean, there's certainly no, intention on the part of post staff to, sort of run roughshod over any appointments that you have. So we would continue to work with you to bring whatever the appointment is into compliance with both the government code requirements and post regulations. This is just a mechanism by which if we finally get to the end and there's been an inappropriate appointment and a proof of eligibility has been issued based on that, that we have some mechanism by which we can walk back that proof of eligibility. But in the short term, it would look much like it does now, where your regional consultants will work with your agencies to correct any deficiencies in the background. But ultimately, the background has to be both post-compliant and compliant with the law in order for that appointment to be valid.
And this would only occur at the point that the audit occurs. So we could have someone basically employed for a period of up to 2 years before this becomes brought to our attention. If I'm going to make the assumption, because I don't know that anyone would intentionally do it, that we misinterpreted and inappropriately appointed, but they could literally be on the books for 2
Sure,
years
and
prior to that.
Yeah, that's actually no different than it is right now. And right now, we don't have any mechanism by which we can actually take action against somebody who's been inappropriately appointed, whether through error or misrepresentation or fraud.
Any other questions on 1204? Okay.
I have a question. How often is this occurring now? Because I mean, we're talking about a process now that you find these things. Do we have numbers? Do we have trends or anything?
I don't have hard numbers. I mean, anecdotally, I can tell you from my experience reviewing backgrounds that it's probably somewhere around 10%. And much of that is due to sort of misinterpretations or misunderstandings. I actually have had agencies where they were actually unable to get the information that they needed. So I can give an example where there was a error with the DOJ report. And so they were working with DOJ in an attempt to fix the fingerprint return that they got, but they had sort of, in good faith established that this person was in fact eligible to be appointed as a peace officer. Again, I think it varies widely based on the agencies. But I don't have a solid number for you on how many errors we're seeing right now.
No, that was good when you said, if you said like 10%, that's a big number versus just one or two here and there.
It can be, and to be clear, there are distinctions in what gets missed. So there's, and I don't want to get into it. I mean, I'm happy to get into it in more detail, but often we find errors that are what we classify as needs improvement. So there are errors that are sort of statutory, they're fairly minor. There's, some difference between what the regulation requires and perhaps what was listed in the background. But there are a fair number where we find just missing documents. And so we continue to work with and that's at the initial stage. I don't want to misrepresent and for you to believe that there's 10% of the folks running around who have, significant background errors. That's during the initial stage. We'll review the background file. Sometimes we'll find missing items. We'll find, problems with maybe a medical screening or psychological screening where the clearance didn't make it into the file, but the agencies, are assured that that actually was done. They just need to go find it. At the time of the audit, they didn't have it. It doesn't remain that way for very long. We continue to work with the agencies to correct those errors.
Chief Brazil, I was working in the field for 4.5 years in that position, and I never had anyone that we weren't able to fix. So it's not as if there are people out there who are working who don't belong in the field. They were just missing a piece of it. And then like Andrew was saying, they would go back to it, figure it out, and then move forward. So it's not something that is a 10%. I think that Charles Sandoval, who also spent 12 years in the field as well, I think that I haven't had one in my entire experience.
So my quick comment is, so this just gives posts the regulatory authority. Should somebody come up that should be decertified, post now can decertify them.
This really isn't decertification. What's driving this is more the issue of at the time of appointment, there's an attestation that's done. The proof of eligibility is issued based on that attestation. If ultimately we got to the point where it appears that somebody was inappropriately appointed, then it would, upon cancellation to the roster, would also cancel the proof of eligibility.
One of the reasons I ask this is, I think we're going to see a whole lot of unintended consequences of SB2. We're going to identify agencies who aren't doing their IA cases correctly at all. And so we're going to see a lot of these things come up where there's a lot more workload on post. Not just about implementing SB2, but about all when we start lifting up rocks and looking underneath, we're going to see a whole lot of things that are just messed up. So I just want to bring that up that, and again, we talk about a lot is we're taking the first bite out of this big monster, and we're going to find a whole lot more work as we continue in this process. We just have to be nimble enough to adapt to it.
Yeah, I think, again, I think the gap that we identified is that there was no regulatory mechanism by which, so if you're appointed to an agency, the attestation was filed, proof of eligibility was issued. Absent this, we actually have no ability to claw back that proof of eligibility, but for serious misconduct. And it may not be serious misconduct. It may just in fact be that you were inappropriately appointed to the agency. And that likely is no fault of the officer who's been appointed. And there's no prejudice associated with this. If you correct the background, if it goes all the way through this process and it gets canceled and you correct the background issue and reappoint the person, there's no issue with that.
Yeah, I'm just seeing a lot more work on at our end. Not when you identify these, we start to identify agencies or the training gaps.
Yeah.
Again, I don't think people are maliciously hiring people that shouldn't be in the business. I just think that sometimes we're missing what we do at Post to give common errors, common mistakes, trends that we see at Post that we can report back to agencies and say, listen, here's some things we identified this as a trend in your background. We identified this as a trend in your IA case, whatever it is, to push that information back out to the chiefs and sheriffs to say, here's some common mistakes we're seeing. You got to fix them.
To AD Sandoval's point, I mean, this is something that your TDC reps do regularly as we interact with the agencies. We help them correct, into deficiencies that we identify in the background.
But I think to Commissioner Brazil's point, because there are some additional things that we need to look at, I think I'd like to make the recommendation that we go a step further than we have is that, and I know this is extra work for staff, is that when you go through your first set of audits, if there are patterns that you're seeing. Like there's things that overall, you know, a lot of agencies are missing that gets reported back so that we can then lessen
Sure.
staff's job when they do the audits, because then we can fix them, you know, because I know we get our own feedback for each agency, but I think it would be helpful to get some overarching, you know, if there are consistent issues in all agencies that you're seeing, especially as we're all trying to navigate this. You know, we sit here every day, but there's, you know, for our meetings and get this information, but other agencies are trying to, you know, glean this from all the workshops and all the things. So I think having that additional information would be extremely helpful, and in the end would save staff because audits will come back much better.
Right. And this is sort of a companion piece to my earlier presentation about 1953. Part of the rationale behind that verification is that it gives our agencies an opportunity to go through and check all of the things that we're going to check prior to. And so my expectation is that this is not, my hope is that this is not going to be needed. It's just again, we had no regulatory mechanism by which to walk back a proof of eligibility that was inappropriately issued based on, you know, perhaps an error in an attestation. So the hope is 1953, the verification will help us go through this on the front end so that we're having fewer issues that we then have to work with the agencies, with the chiefs and the sheriffs to correct. And I don't anticipate, you know, I would hope we don't get to the point where we actually need to take action under this particular section.
And to further that, if I could, Commissioner Gordon, we are anticipating, our vision is longer term, obviously not this year, but eventually to be able to review these backgrounds electronically in advance prior to issuing the proof of eligibility. So that's our long-term vision. We're just having to take these things in steps. So thank you.
And if I may, Jackie, for Commissioner Gordon, we can put something on in a year and have our training, delivery and compliance folks as a consent item. Say, hey, here's what we're seeing, the issues, and here are the best practices that we're seeing to keep you posted statewide is what we're seeing with the appointments. That should be easy for us to do. Okay, thank you.
Thank you. Important discussion. So that was on 1204. Is there any other comments or questions on 1204? Appreciate all the discussion. Moving on to 1206.
Madam Chair, can I make a recommendation, please? 1206 is going to require two motions. So would it be convenient at this time to take a motion on 1203 and 1204 and handle 1206 separately?
Sure.
Okay, thank you.
So at this time, let's see. Is there a motion to approve the changes as described in 1203 and 1204 as described in the staff report? Second, all in favor?
Aye.
Oppose? Hearing nothing, the motion passes, and now we're on to 1206.
Thank you, Madam Chair. I'd like to introduce law enforcement consultant Darren Grimes for 1206 presentation.
Thank you. Good afternoon. It's law enforcement consultant Darren Green. It's okay. Regulation 1206 was created to identify the procedures and responsibilities of the Peace Officer Standards Accountability Division regarding investigations and receiving public complaints regarding peace officer misconduct. So it provides the division authority to review and investigate misconduct allegations for the purpose of decertification, to review any agency or other investigative file, as well as conduct additional investigations if necessary, and to investigate without the request of the commission or board any serious misconduct for revocation of a peace officer certification. Investigations may be conducted for the following reasons: an agency's investigation was inadequate or improper, an agency refuses the division's request to review or investigate an allegation of serious misconduct, refuses to provide the division a copy of its administrative investigation, or to conduct further investigation at the division request. Provides basic rights to a peace officer if and when interrogated by the division, including the officer will be informed of the nature of the investigation prior to the investigation. They will be provided written notice of the date, time, and location of the interrogation. They will have the right to representation during an interrogation. And if the interrogation of the officer is recorded, the officer will be entitled to a copy of that recording prior to any future and subsequent interrogation. The officer will be allowed to attend to their physical needs during an interrogation. 1206 also establishes procedure for accepting complaints from members of the public regarding peace officers or law enforcement agencies which may be investigated by the division or referred to a peace officers employing agency. Those procedures are through the post website, email, telephone, mail, in person, and facsimile. Complaints received will be reviewed and forwarded to the employing agency as appropriate. If the allegation rises to the level of serious misconduct as defined, the agency shall report to the division per Commission Regulation 1207. The employing agency has the primary responsibility for completing investigations into serious misconduct. The board may request the division to review an investigative file or recommend the commission direct the division to investigate any potential grounds for decertification of a peace officer upon majority vote, or for allegations of serious misconduct as defined, for allegations of serious misconduct pending investigation by the employing agency, allegations of serious misconduct already under review by the division, or allegations of serious misconduct that has already been reviewed and closed by the agency or the division. Upon recommendation by the division for decertification or suspension, the affected peace officer may request a review of the division's findings before the board and commission for review per Commission Regulation 1209. If the affected peace officer does not request a review of the findings, the recommended action will stand without further proceeding per Commission Regulation 1209. And post staff reevaluated this regulation and realized the peace officer rights component was not originally included. Therefore, the proposed regulation was amended to include this information. If the commission concurs, the appropriate action would be a motion to approve the proposed regulation 1206. And then if that is approved, if the commission approves the first motion, the appropriate action would be to approve the amendment to 1206. And I
Understand. Any questions?
Just for the record, included in the agenda, we did receive a public comment on this regulation from the American Civil Liberties Union. You should have that information in your packet. I just want you to be aware that there was a comment during the public comment period for this regulation. Thank you.
Thank you, Mr. Evers. Okay, did the advisory committee have any comments on that first part of 1206?
No additional comments.
Okay. And is there a motion to approve the changes as described in 1206 staff report? Thank you. Second? Any further questions? All in favor? Oppose? Okay, hearing nothing, that passes. Now 1206 Part B.
So, Madam Chair, we need a second motion for the modification to the proposed text.
I couldn't understand you. I'm sorry. I couldn't hear you or say it again.
So we took a motion for the initial suggested language and then we modified the text. So since the first motion was approved and that a second motion needs to be approved to the modified text that we changed, which is the verbiage in the red. So we need a modification
Right.
approval, please.
Okay,
Thank you.
so have we heard the modification? We did. That was the second part of what you said. You said first we vote on 1206 Part 1, and then if that passes, then the modification in Part 2.
correct. So the second part was involving the peace officer's rights during an interview, which I read it through. It should be in red.
So just to be clear, then that is the modification. Did the advisory committee have any comments on that part?
No additional comments.
Any further questions? Is there a motion? Second? All in favor? Oppose? Okay, that motion passes as to the modification as to 1206. On to 12, no, it's very important. You're doing what you're doing. And now on to 1207, please.
Thank you, Madam Chair. I'd like to introduce law enforcement consultant Steve Harding to present on 1207.
Thank you. This is a new regulation 1207, and this is going to cover the requirements for agencies of what they have to report to us when they come across any complaint, charge, or allegation of serious misconduct. This is broken down into what they are going to be required to report to us within 10 days. And then at the conclusion of the investigation, what they need to follow up with and provide to us. Within there, there's also a requirement that every 90 days they provide us an update. According to Mark 43, that will be an automatic update that will come through the system, through the software system, just to give us an update every 90 days on what's going on with the investigation. As we know, sometimes these things can last up to a year. Also, this will also cover that we will toll moving forward with these investigations once we have everything. If there is any sort of pending criminal case, or if the officer is review, or if they're appealing any kind of a proposed discipline within that. Does anybody have any questions?
Questions on 1207?
What was that last part about? We're tolling, I understand the criminal tolling. We're tolling if they're appealing their discipline.
If there's imposed discipline and it's moving through a process, we're going to hold off moving forward with our stuff and wait for that to be over before we move forward.
When you mean holding off, or holding off submitting it to the board.
Correct.
You're not holding off on the work you do and
Correct.
the background. So I just want to be clear, because people out there, that we're doing our process at our end, us being post. The agency's doing theirs, we're doing ours. We're just holding off and submitting it through the review process, the final review process to the board until they're done with their whatever litigation, criminal or the appeal process.
Yes, sir.
Thank you for that clarification. Did the advisory panel have any, committee, excuse me, have any comments on 1207?
Madam Chair, on this item, there were questions with regards to the volume of cases that may be coming before the commission or before the Accountability Advisory Board. And then as to how some of this information, there was a comment made that the Post was already attempting to gather information to get an idea on the volume. So there was some discussion as to how that process occurs. If Post became aware of a potential qualifying case that was seen in the news, do they contact the agency and work with the agencies and staff appropriately address those questions for the committee? No additional comments.
Okay, want to address that? No? Are they seeking for the commission to address anything there, or just making the comment?
There were questions with regards to that process, and Jackie handled those questions, and there were no additional concerns.
Okay, thank you so much. Yes.
Just a quick question, the tolling provision, is that an attempt to toll this 3-year statute of limitations, or you're just saying that the review will be basically stayed or halted pending the completion of the
The
process?
review, I don't think we can mess with the 3-year thing.
That's, yeah, that was what I was asking.
No, we're just going to hold off. Obviously, if it looks like it's going to get extended, we're probably going to have to move forward. But I think it would be better if we were able to advise the board and the commission if somebody was actually terminated or not. That would give them better.
Thank you. Any further comments or questions on 1207? Yes, Commissioner Gordon.
Now he caused me to have a new question on the tolling. If as in terms of the advisory board and the commission, we're looking at this 3-year issue. If we're not getting it till later, it's one that goes through the administrative law judge process. We might be pressed for time if we don't start our process soon enough. So that is one concern with that. And then, because appeals on a city or a county end could take a long time. We make a final determination. So I issue a notice of termination. They have their initial Scully. And then once that happens, yes, there are more that they can take, but are you saying we're going to wait till later when it works its way through that? Because that's of concern at how much time the advisory board and the commission has to do their work, as well as the administrative law judge. So that's my first question.
Yeah, that's my concern as well. And depending on how things happen at the local level, you can, you have your Skelly and all that stuff, and then you can have a local appeals process. It can go to grievance or arbitration or a hearing board. And then that can take a long period of time. And then ultimately, when there's a decision there, then somebody can file a writ of mandate in Superior Court and challenge that. And then it can go up to the Court of Appeals. So I just wanted to make sure that I understood what the idea is with the tolling provision.
Okay, so to address a couple of those concerns, First of all, the 3-year rule is that the investigation shall be completed. So it's not the due process portion of it. So only the investigation needs to be completed within 3 years of receiving the completed report of the disciplinary from the agency. So it doesn't have an effect on the board in the process. Second to that, I think it's our intent not to toll these cases if they are ongoing multiple levels of review. We're referring specifically, and if we want to amend the language, we can, but to like the Skelly hearings or the initial level of adjudication through whatever their bargaining agreements allow for, not for the continual appeals that go on, for into perpetuity. So that's the intent of this portion of it. And actually, to further that, let me just read into the record how we have it written into regulation so you guys can see how we have it. If the imposed discipline is pending a review by a dispute resolution mechanism, the agency shall provide the commission with the body conducting the dispute resolution and the status of the hearing, if known. The commission shall toll the review of the investigation pending disposition of the hearing. That's the verbiage that we have proposed. So I'll put that up for discussion if you'd like to amend that.
Thank you, Commissioner Brazil.
Would it help you? Because once I pulled up the language, there's a couple of cases where it says the commission would it be easier for you if the commission may toll the review? In case it goes on for years and years the intent is that we wait till it's done, but if it's being stalled out and it's something we want to do, and there's a couple of cases like in criminal charges as well, or the commission it says shall. So the first one would be F(1), which says the commission shall toll the review. Would you like it to say may? I would encourage that. And then when it comes to the criminal side too, the commission, that's G1, the commission shall toll the review is may.
Yes, so stand by one. There's something in SB2 right here I want to read to you that does not give us the authority. Okay, so under Penal Code 13510.9, it specifically states the time limit shall be tolled during an appeal of a termination or other disciplinary actions through administrative or judicial proceedings or during any criminal prosecution. So we do not have the ability to not toll that. Does that make sense? So unfortunately, that's from SB2 specifically, or not unfortunately, but
Yeah, I'm just looking, that was 13.510.9. And what was the subsection? Don't. I don't have that in E. I'd have to look at it. I mean, I guess I wasn't asked to look at this beforehand. If you're convinced that it's the statutory language and we need to have it, then I guess we do. But again, I don't see that in 13.510.9E. I wanted to make sure that we understand, what it is, what the intention is. No, I mean, I think. You want to move on? maybe to the next one and then we can look at that. Do you want to jump to,
1208.
yeah, 1208?
Okay.
Can I ask one quick more follow-up on 1207, just so I'm clear on the legislative intent and the language? When we talk about civil judgment or court finding, does that include a court settlement? Have we made that determination in terms of what, when it's been looked at in terms of the interpretation of SB2? If a city settles, is that also included?
Under 13.5.10.9, the report includes a civil judgment or court finding against a peace officer based on conduct or the settlement of a civil claim against a peace officer or an agency based on allegations of conduct that could render a peace officer subject to suspension or revocation. So that's in the statute. It's under 13.5.10.9. So it's a settlement of conduct that could be the basis for revocation.
Okay. Anything else on 1207? Okay, what we're gonna do is take a break now.
Yes.
And stop and come back at 2:30 and give Toby some time. Okay, everyone, thank you so much. And special thanks to Toby, who spent some time reviewing it, and now he's going to explain it to all of us.
Yeah, well, we'll see.
Okay. And again, just to remind everybody where we are, we're talking about 1206.
All right, so really the question was just so that we understood the tolling provision. The statutory reference is actually Penal Code 13.510.8. Let's see. The 5, it looks like. And basically what that provision says is that it talks about the 3 years, that the investigation has completed within 3 years after the receipt of the completed report of the disciplinary or internal affairs investigation from the employing agency. It says, but no time limit shall apply if a report was not made to the commission. The investigation is considered completed upon the notice of intent to deny, suspend, or revoke certification pursuant to subdivision E. And then it says this time limit, and this is referring to the 3-year time limit for completion of the investigation. The time limit shall be tolled during the appeal of a termination or other disciplinary action through an administrative or judicial proceeding or during any criminal prosecution of the peace officer. So the language in the regulation is staff's implementation of that section in 13.510.8. And so I think it's clear now that we've looked at the statute that that's the intent, and that when staff refers to the dispute resolution mechanism, that is referring pursuant to the statute to the process that is specified by the legislature, which is the appeal of a termination or other disciplinary action through an administrative or judicial proceeding. So that's how we should interpret that.
Any additional questions on 1206? Okay. So now we're ready to take the vote on 1206, the motion.
1207, Madam Chair.
1207.
Yes.
1207. You're just reading. Okay.
Who knows?
Did the advisory committee have any comments on 1207?
No additional comment.
Okay. Is there a motion to approve the changes as described in 1207 in the staff report? Second? All in favor?
Aye.
Oppose? That passes. On to 1208, please.
Yes, thank you. And I feel justified. Thank you, Toby. Okay, so anyway, 1208, I'll be presenting this one for you all. So post staff proposes to adopt Commission Regulation 1208, temporary suspension, to establish the executive director's authority to temporarily suspend a peace officer's certification pursuant to Penal Code Section 13.510.8. As this is a new authority for the executive director, Post determined it was necessary to codify it in regulation. The proposed language identifies the reasons for an immediate temporary suspension, which are an arrest or indictment of a peace officer for any crime described in Government Code 1029, discharge from any law enforcement agency if the person is or has become ineligible to hold office as a peace officer pursuant to Government Code Section 1029, or separation from employment of a peace officer pending investigation of allegations of serious misconduct or resigned in lieu of. Additional language includes the notification requirements following the issuance of the temporary suspension. This is pretty short regulation. So any questions on that?
Questions on 1208? Did the advisory committee have any comments on 1208?
No comments until.
Thank you. Is there a motion to approve the changes as described in the staff report as to 1208?
So move. Second.
And all in favor?
Aye.
Oppose? That passes. On to 1209.
Thank you, Madam Chair. Post staff proposes to adopt Commission Regulation 1209, notification of completed investigation, officer rights to review, and hearing procedures to establish the following. Post responsibility upon completion of an investigation of alleged serious misconduct, the procedure for notifying a peace officer of the division's findings and recommendation to include The notice that reasonable grounds were not found for suspension or revocation, or notice of intent for suspension or revocation of certification. The peace officer's rights to request a hearing to review the intent to suspend or revoke by the board and commission. Notice that the division's recommendation will stand without further proceedings if the request for review is not received within 30 days of the notice. The proposed regulation will also incorporate by reference the request for review of peace officer certification form post 2-359 to standardize the process and request a review of the division's recommendation to the board and commission to suspend or revoke a peace officer certification. This proposed regulation also addresses the following: that a peace officer may voluntarily surrender their certification, which is permanent and has the same effect as a revocation, establishes the review process if a request is received, which includes the board shall schedule a case for hearing as soon as practical to determine whether clear and convincing evidence exists. The peace officer will be provided with a copy of all materials used by the division to render the decision. The board shall review the findings presented by the division and make a recommendation, and the commission shall review the recommendation made by the board and determine whether clear and convincing evidence exists, and if so, it shall be provided to an administrative law judge. It also includes the board and commission hearing review process, which includes formal rules of evidence do not apply. The division shall present its findings to the board and commission. The peace officer or their representative may provide written and oral arguments if so desired. No witness testimony or public comment are permitted during that hearing. And each side's presentation should be no more than 30 minutes in length unless additional time is granted by the chair. And that concludes the overview. I'll be happy to answer any questions.
Thank you. 1209 questions? Yes.
Madam Chair, I do have a question. 1209 was also covered in the ACLU's letter. And they had some questions about whether the board would get the complete files because it says findings. So I just want to know what Toby says they get or don't get.
Yeah, it raises a difficult question. So this is one of those things that I think we'll have to figure out as we go along. I hate to say that, but the reality is that there's an issue with the intersection of privacy laws, what is already considered public information under Senate Bill 1421 and Senate Bill 16, and what information isn't. So if we have information in form of an IA, and it might include information that is, for instance, it may involve a child victim, or there may just be confidential information which we need to be very careful about before we make that part of a public record. Jackie, I haven't had any lengthy discussions with the SB2 team on it, but just my work in this area leads me to conclude that if the full packet is information which is already subject to public release under Senate Bill 1421 or Senate Bill 16, in other words, it is one of those areas that the legislature has already determined is suitable for release to the public, then there certainly isn't any issue with all of that material being included as part of the public record, and that information then being considered by the board and by the commission. The difficulty is going to be any areas where there is information which is arguably not subject to that. And as to those materials, then the question's going to be, is that information effectively going to be sealed and revealed only within a closed session context to the board, or is the division going to, in essence, include it as part of the package? And by virtue of the fact that it's included as part of the package and given to the board, it then becomes public by operation of Senate Bill 2. And I haven't had this lengthy discussion really yet with staff. Jackie, I don't know how you and the SB2 team are looking at that, but that just based on my experience, and I've litigated 1421 and SB2 and pitches issues for many years. So That's just my thought based on my knowledge of the litigation in this area. I don't know what the SB2 team is thinking.
Yeah, I think at this point, our intent is to provide the entire case file to both the board and commission. And assuming that any appropriate redactions will be made prior to doing so.
So the idea is then, there may be certain redactions which should be made that really, the board or the commission doesn't need a home address, for instance, that sort of thing. But then there may be some redactions of information because it's private. And yet the board or the commission may need to see that information. So if that's the case, then the redaction might be made from the part of the report which is put in the public record. But presumably the board and the commission would have the ability in some sort of closed session format to see that evidence to the extent that it's relevant to the determination. Is that right? That's kind of what I'm thinking.
Yes, you're exactly correct.
Is that also the way that it's done by, I know that you folks went and talked to a lot of different states that do these. Is that the way that a similar situation is handled by other states like Arizona and other ones that you looked at?
Yes, we have seen that in other states where the confidential information can be deliberated upon in closed session.
But I think in the case of a child, the name can be omitted from both and isn't necessary. So I think there can be circumstances when the board, when all three of those things occur. Okay, thank you. Anything else on 1209?
Couple things, quick question regarding the confidentiality and the investigation in terms of being public. So currently, when you have an investigation and it's ongoing, you're not releasing that.
Right.
So my question is, because Post can ask for further investigation, the board, and like, we can go back with this. Would we consider that currently under an investigation? Because sometimes this is going to become public information sooner than it should in terms of then what happens with it, in the public eye before it's actually been fully investigated to meet the standard of everyone involved. So that would be my question is, at what point does it really become a closed investigation that can be released fully and publicly? And the second part of that is, in terms of this commission and the board, what information will be publicly, when those discussions happen, be publicly debated? Does that make sense? I don't know if I'm asking the question correctly.
Well, it strikes me that we're talking about a couple of things, and I think ultimately we haven't talked about this yet, but I think that we should be thinking about, as an organization, the question of when information is reported, the form in which it's reported. At some point, if there's an IA or a complaint, an internal affairs complaint or a citizen's complaint, and it's being investigated, at some point it's determined if it's sustained or not, right? And at the point where it's sustained or not, and then looking at the other hoops within 1421, because if you're familiar with 1421, I'm sure you are, it's, there's a process in there for determining when the material is subject to release under the Public Records Act, under 1421, if it's a sustained finding and the other hoops are jumped through. So that's a determination presumably the agency would have made, that at some point that this is subject to release under 1421. And then and also, as I'm sure it's probably happened certainly in high profile cases where there already have been media requests or other requests made under 1421 for the materials, in which case presumably the agency's already done that and they have a redacted copy available under 1421 or Senate Bill 16. There certainly are procedures in there that it could be a period of time before it's determined at the agency level that it's subject to release under 1421 or 16, right?
But if those records are now becoming post records, that's my question is,
But now, and again, I'm looking to the SB2 team. I think that for the most part, and Jackie, you can help us all on this. I think for the most part, the commission is looking to the agency in the first place Post is going to want to be notified of the fact that there's an ongoing investigation. But then Post is for the most part going to wait to see if there's a determination made by the agency, right? So then we would know if it was sustained or not and so forth. Now, I suppose there may be circumstances that we'll have to face where an issue comes in and the division may want to start to do an investigation before the agency has sustained the findings or completed its investigation, and we're gonna have to figure that out.
What would that look like? I'm trying to figure out a time when we would start investigating, when the agency hadn't finished their investigation yet. I can't imagine what that would be.
Or if there's, my question comes in when there's additional investigation being done as well by post.
So if I understand the question, yes, hypothetically speaking, a department completes their investigation within a 1-year time period. They now submit it. They're done with what they've done. And now we have 3 years to conduct the review and the investigation by the penal code. During that 3-year window, are those records subject to a Public Records Act request? Toby, I don't want to interpret the law, but I would imagine that if we are conducting a review and an investigation during that time period, since it is still under investigation by post, that it would not be subject to a Public Records Act request. Is that your
That's
question,
exactly my
Commissioner?
question is, I understand what our obligation is as an agency. I'm trying to understand once it becomes in post hands, what is post's obligation in terms of under investigation and what that means in terms of the law? At what point then would post release additional information they may have gathered during their investigation?
Very good question, and I promise you that we're gonna end up in litigation over this very quickly. Because what's gonna happen is, I think we're gonna end up getting PRA requests and folks are gonna try to get information from us. If they can't get it from the local agency, it's gonna happen. And I don't want to speak, I don't want to bind us legally when we don't have a specific factual situation in front of us, but I can tell you generally what I tell the PRA team here when I get a PRA question. And that is that when a PRA request comes in, we look at the request, we look at what documents we have that are responsive to the request, and then we determine if there is a privilege or not that applies to it. So I think what would happen is if we have received material from the agency that presumably is still subject to pitches protections, if it's not subject to release under 1421 or 16, and it contains material which staff determines is subject to privacy objection, subject to 1421, subject to pitches, or subject to some other, perhaps the official information privilege or the deliberative process, something along those lines. And so the determination at that point would be, yes, this material is not subject to release. Post would then make an objection to the requester. The requester would then, if they wanted to, and they do it all the time, file a lawsuit. And then we would end up litigating the propriety of whether or not we should do it or not. I tend to be, in my advice to the commission, I tend to be pretty protective of privileges and so forth. But at the same time, we do have an obligation under the PRA. That's also in the state constitution that, it's the sunshine law and you have to produce information which is subject to public inspection. So in all cases, we simply have to do that analysis and then try to make a determination as to whether or not it is subject to release or not. It's going to be difficult.
If I may, I think the Public Records Act issues are very complex. We've had a lot of discussions about them, and I think it's fair to say we were discussing it yesterday, that we're not putting it on the back burner, but I think we were prioritizing all of this with the intention of addressing the Public Records Act issues in the very near future after we complete all of this. At least that's what we were saying yesterday, because they are so complex. We were already discussing the potential issues that would come before the bill was even signed as to how we're going to have to respond to this. Is that fair to say? I know, Jackie, we spoke about it just yesterday. Is there anything else that you want to add about it?
No, you're absolutely correct, Manny. With the timeframe has been so condensed in order to get us to today, that this is just one of those that we're going to have to deal with once we get past this particular portion of it, but it is on our list, I promise.
Okay, and just one other quick question is when an officer notifies post that they're going to exercise their right to contest and appeal the decision, it says here that they will notify post. Is there any way that the agency itself will get notified that they are contesting it? Because I don't see that specifically in the regulation. It says that they have 30 days to notify posts. But there's nothing within the regulation that says that the agency will also get notified that they're now moving forward with the appeal process to post.
Yeah, let me look at the regulation, but if that is not in there, we certainly can add that, a notification to the employing or former employing agency. I don't think that should be any problem at all.
So Jackie, just to elaborate on, to confirm, so I'm clear, there is a requirement that we notify the agency or the department, the district attorney and such when we're conducting a review. I guess the question is if they, on the back end, what happens when the person does come in and say,
Yeah,
yes, I want to
in reading through the
then go
regulation,
back.
Yes,
and
in the
say, by the
regulation,
way-
it doesn't say that, yes, we'll get notified on the front end, but if then the officer appeals, the agency should also be notified that the appeals has been made.
Yeah, and I would hope, I don't want to speak for the team, but I would, regardless of the decision, whether the person appealed or did not, perhaps there should be a second notification that's made to the department and the district attorney and whoever else is listed in SB2 as to whether the person requested a review or not, if that's doable.
Anything else on 1209? Yes. Commissioner.
I'm that guy. So it pertains to the top part. When you're looking at the language, when the division finds that there's no reasonable grounds for revocation or suspension. When we say division, what's the approving authority for there's no grounds for revocation and suspension? It just says division.
Yeah, that will be the Peace Officer Standards and Accountability Division, the Posts Division.
So,
We'll make that recommendation.
so is it the team lead? Does it go to the AD? Does it go to the Manny? That's the question, is where does it go to say, okay, we're good with this, we're not moving forward?
Yeah, so we're in the process of creating that, that process right now, but our vision that we see is that we're going to have every case, regardless if it's meets the threshold for decertification or not. Every one of those cases will be reviewed by the bureau chiefs and our legal team as a whole, so that all of the cases are being evaluated consistently from each investigator to each region, from agency to agency. And then we will have all of those, and it'll have to be the majority vote with the bureau chiefs and the legal team that, yes, that we're in agreement in this action and needs to progress or it doesn't. And then if we can't come to a consensus internally within the bureau chiefs and our legal team, then we would up it to the AED for final decision authority on that. So we are developing these processes to make sure that it's not just Mark and I making the decision on whether or not we think that a certification should be revoked or not. I hope that answered that. We're working on that. But we understand your concern.
Yeah, because right now it says if the division does not find reasonable grounds, the division will notify the officer, the division will notify the agency.
Correct.
I'm just trying to figure out where that exposes mid-level management to a lot of risk or making a determination that's not appropriate. That makes sense, because you're making a determination we're not moving forward. So I just want to make sure we put it at the high enough level within the organ that one person makes the final sign off.
So you,
Not, because if we start ending up with 3 or 4 divisions, and granted, I get we're trying to be consistent, but somewhere along the line, there needs to be somebody, whether it's Manny or somebody higher level says, okay, I agree, we're not moving forward with it. We're gonna let the employee know and the agency know, because it's only gonna take one time or we push it back that ends up in some newspaper somewhere that we didn't take them through the process because our process didn't review it appropriately. Does that make sense?
Yeah.
I'm just worried about that.
Yes, so the process that we're hoping to do will be that the division will make a determination. And then that the division will then forward the information to a panel of individuals within post. 3 individuals, similar to how a district attorney's office reviews cases at times like capital cases, one being the chief counsel or the chief counsel's designee and attorney, two other individuals to then make a second review to move it forward or not move it forward, including those matters that we are not going to move forward, just to make that confirmation. And then obviously that information would then roll to the executive director to either sign or to move it forward or not move it forward. So it adds a significant level of review, but I think it's important that it not just be contained within the individuals within that division, that there should be some other individuals that do a secondary review, and that would be a panel of individuals.
Yeah, no, I like the process, right? And I assume we had that, but it isn't reflected that way in 1209. So it might be that maybe we just change the language that instead of the division does not find reasonable grounds, it's post. So
Yeah.
that you can identify what process you want in here that's, anyway, if that, I just have concerns. I know what our process is going to be, what it's going to be like 10 years from now, who knows? But it gives you the authority to kind of modify and do things internally that's not aren't in code.
I don't have any problem with that, making that change if you want to make that change, but it strikes me that's really more a matter of internal procedure. Manny, as the executive director, you're going to have internally, you're going to have procedures about how the flow works on this. And so presumably it'll be well established in your internal procedure that the division makes a recommendation, it goes to this 3-member panel and then ultimately goes up to you because, you know, the buck stops right there. So, I mean, we certainly could put that in regulation, but I don't feel like we absolutely have to, as long as Manny has it clear as a matter of internal procedure. He'll, you know, the staff will know what the procedure is. That's kind of my thought.
We're writing it for
Different about
staff,
it.
we're writing it for everybody else.
Yeah.
So I'm looking at it from an outsider's perspective. It's like, who's the division, who's in charge, and how come the boss isn't making the decision? Or if I'm a police chief, who's the division and how come, you know, it's not. It's like internal affairs doesn't make the final conclusion that chief does or the sheriff does. I mean.
Can it be something such as the either post, as you mentioned, or the executive director or his or her designee?
Can we, what a suggestion would be, just changing division to the commission, small c, meaning staff, overall post. That's how our regulations say, or the commission.
That
I don't
kind of
know.
bring the question, well, then who is the commission again? Is that I have no issue personally with like executive director or his or her designee.
Okay.
And then it could be the deputy director, it could be an assistant executive director, and we don't codify the procedures that I just outlined, which could change pretty regularly. But it kind of gives some comfort that it's done at the highest levels of post. Is that doable?
Yeah, it's good for me. I knew it was going to go to a higher level, but it didn't read that way. I mean, it's just, and again, I'm looking from an outsider's perspective looking in, and you've got now 3 divisions, maybe 4, and we're still not sure what that is. And I think if it's you or the executive director or designee, there's a
that
final
what-
sign off. Somebody
is that
final
okay?
signs off.
Yeah, of course. I mean, in staff defense, I think it's probably because the way that the SB2 is written, you know, you have the division doing certain things and then that goes to the board and then that goes to the commission and then that goes to the ALJ. So it's sort of the way the statute was written. But certainly understand the point. And I mean, I think if what you want to do is amend it, so it sounds like in 1209, the recommendation is that division is going to be replaced with executive director or his or her designee. Is that the idea? What do you think about that?
Yeah, I'm fine with that. So just for clarification, I would put under A1 and A2, instead of the division is the executive director or their designee.
Oh, no, that, I think that'd be great. I think it'd be for personally.
Anything else on 1209? We are very, very close. Okay, so as to 1209, did the advisory committee have any comments?
Comments were only related to similar topics that were raised in this discussion here with regards to liability, whether revocation or failure to revoke and PRAs, but the staff addressed that as did Director Alvarez.
Thank you so much. So is there a motion to approve the changes as described in the staff report as to 1209?
As amended by Commissioner Brazil.
Yes, as amended by Commissioner Brazil's language. Commissioner Brazil, do you want to make that motion?
Didn't somebody else have one more language change? My brain's.
So for clarification, please, Commissioner, so you would like to have the notice to the agency at the time we make the recommendation and whether or not the officer has requested a review of that certification? So double notification on the same action?
So that poses a question, at least in my mind. I know that the law requires notification. Should that notification just be one time on the back end? So we make the notification to the individual makes whatever decision they make, and then we notify the department, the district attorney and such, or are we required by the law to immediately notify the department, the DA, when we make the notification to the individual? I'm just trying to see if that minimizes the labor or the potential issues that would come with one. I understand the department wants to know the outcome for sure, right? So
Department also wants to know whether there's an appeal in process, because that does affect.
yeah, and I mean outcome by what did the person decide to do? Is this moving forward? Is it not?
Yes.
Did
Did the officer exercise their right to appeal or did they not?
Yeah.
Because right now, if you read what it states in E, upon recommendation by the division that a certification of a peace officer be suspended or revoked. One, the peace officer may request a review of the division's findings before the board. And then two, if the peace officer does not request a review of the division's findings, the recommendation will stand without further proceedings per. So my recommendation would be that we also add to that the agency will be notified whether they accepted the recommendation of post or whether they're appealing it.
So that's an easy enough amendment to make if that's what you would like to add. That does put a little extra burden on post, I will say. So just for discussion, is that a post responsibility or is that an agency responsibility to follow up on that? Just throwing that out there for discussion.
I would
We
also
can
think
easily
that
make it.
if the employing agency was taking action against the officer because of a certification problem, that it would be the officer's responsibility to notify his employing agency that he had filed the appeal, but
That's assuming they're still employed.
right, true.
I think we err on the side of over notify the agency at the same time. Hey, by the way, we sent the letter out saying that Rick Brazil's being decertified or suspended. And he's asserting his right to appeal, just a heads up. Because they may want to be witnesses and everything else. So it gives them a heads up that it's coming. And
That's
then
my
the final
point is
decision.
the agency does have some burden that they're gonna have to present, if there's witnesses and there's people called, the agency should know that it's coming. So, and it can be done hopefully through software. I mean, hopefully you just get a notification that, and I'm oversimplifying this, but there can be a checkbox within appeal was filed, yes or no, and we get a notification whether that appeal was filed or not.
So we can certainly add that, but just as a point of clarification, there won't be witness testimony during these hearings. So there won't be a need to put witnesses on standby, for example.
But if it were to go to the ALJ, there's more to that process, so.
I thought we said that during the appeal process, the employee could present, you would present 30 minutes, the employee could present 30 minutes.
That's correct, but
Okay.
additional witnesses outside of that won't be able to testify at the board or the commission only at the ALJ.
So Jackie and everybody else probably kill me for saying this, but not knowing how Mark 43 or the software solution is going to work. I don't know if some of this can be automated, as you say. In an ideal world, in a perfect world, it would be great if we could make notifications to the department, to all those entities like the DA that are called for in SB2 with every step of the procedures, right? So we now have it scheduled before the board. Would the department like to receive an email saying, hey, this matter blank, blank, blank is scheduled to be heard by the board on, X date. Hey, it's now scheduled to go to the commission on such and such a date. Hey, it's been forwarded to the ALJ. I don't know if that can be automated so that we don't have to continue writing letters back and forth, but I would imagine that that would potentially be helpful for you to know each step of the way that it's going through.
It would be, but I think more importantly, just knowing that it's moving forward. If that can, be built in as we move along, yes, fantastic. But, I do understand there needs to be some, burden on the agency to kind of keep track at that point, but we have to know that we need to keep track.
Okay.
Can I make a recommendation, please?
If you get this form, the request for review of peace officer certification, can you just, as part of an internal matter, you copy it to, oh, sorry. I'm just wondering if maybe can be resolved by just internally, when you get one of these, the processing of the form includes a copy to the employing agency.
What do you
I may-
think, Jackie? on
Yeah,
that?
I have a thought on this, and one is, can we table that suggestion until we see what the abilities of our Mark 43 system has? And then if it's able to do that or not, we can come back and amend this regulation as we get further down that line, the process? Or do you, if not, we can add it into very clearly, just add the similar language that we currently have when we do make the notification to the officer that we're going to recommend revocation or suspension. We also notify the agency head that employs or employed the individual peace officer. We can add that same verbiage into the appeal or the review as requested by the officer. So we can do it either way. I'm just throwing out two options for you.
So Jackie, just to summarize what you just said, it sounds like your preference is, let's do this now and let us work with Mark 43 and amend this if not, when we find what they can and cannot do to simplify the process, with the understanding that the commissioner would like, obviously, to get some kind of a notification that we can work through. Is that reasonable to request, at least from you all, to move this thing forward now and then let us come back with a modification in 6 months or so? Is that what you're asking, Jack?
It's certainly easier to add to the regulation justification wise than to have to remove things from there. So I would, my preference would be to do this in stages, but I certainly will accept whatever direction you all would like to go in today.
Well, if we just put in, we're notifying the department that there's an appeal, we wouldn't have to remove it. We would just establish whatever process is easiest, right? Whether it's through Mark 43 or somewhere else. Last thing you want is a chief or sheriff being blindsided by the media saying, by the way, your employee you fired of this high profile case is appealing it, because it's going to be public. Once they appeal it, the world's going to know about it. But if we don't notify the chief or sheriff, they may not. We don't want to blindside them that some high profile case is being appealed and they don't have any knowledge of it.
That would also be my preference.
Is there some language, Jackie, a few words that we can add to it now that would cover that? And then we can come back with, hey, here's how we anticipate we can
Sure, I
execute on that direction.
Could we just add that post will notify the agency on the peace officer's decision on appeal?
I'm just looking at the proposed language and I'm wondering if we could add it under A2, which is if the post commission finds reasonable grounds for revocation or suspension of a peace officer certification, it shall take the appropriate steps to promptly make notification in writing to the agency head that employs or employed the involved peace officer. What if we just add a second sentence to that? That says the agency will be further notified if a request for review is received. Something of that nature. Does that make sense?
Sorry, where if there's a request for appeal, because I think it specifically, that language specifically talks about appeal, whether the officer, in keeping with what the language of SB2 says, requests a appeal or does it say appeal within the legislation? I just want to make sure we're consistent.
Review. Yeah.
Can it just have a sentence to something like this, Jackie? that
I'm working on
says-
it, yeah.
Yeah. The decision of the individual, whether to request a review or not, shall be, notification shall be made to the department.
It might make sense, Jackie, to put it under B. Let's see, B3. It talks about if a request for review is received, and then it talks about what will happen. The peace officer shall be provided with copies, et cetera. Board shall review the finding. Maybe that's the place to stick it. Just wherever the appropriate place is to say that the agency will be notified if the request for review is filed. Wherever you think is the best place.
Can I please have a moment to wordsmith this? Maybe we can come back to this one while I work on this and present the next one, which is 1210. Is that
Okay, we'll
satisfactory?
pause on 1209.
Pause on 1209.
1210.
Thank you. Thank you. And then I will introduce law enforcement consultant Mark Nagel, who will present 1210. Thank you.
Good afternoon. Thank you. Commission Regulation 1210 is the voluntary surrender of certification. Section 13510.8 has been added to the penal code to include the ability for a peace officer to voluntarily surrender their certification. After a review of SB2, it was determined there needs to be regulation to identify the requirements and procedures for the voluntary surrender of a peace officer certification. These would include establishing that any peace officer may voluntarily surrender their certification permanently, include the reason that a peace officer surrenders their certification. The proposed regulation will also incorporate by reference the voluntary surrender of peace officer certification form 2-358 to standardize the process and obtain required information, and to comply with the commission's responsibility to report any voluntary surrender to the National Decertification Index and indicate the number of voluntary surrenders received by the Post Standards Accountability Division in the annual report.
Okay, questions? I have a question. Is the district attorney's office notified in a situation like that?
I believe they are. Yes.
Anything else? Okay, did the advisory committee have any suggestions on 1210?
No suggestions, just procedural questions as to circumstances this would occur and why it would be on the integrity bulletin or the NDI, but staff explained that and it's codified.
Okay, thank you. Is there a motion to approve the changes as described in the staff report as to 1210? Second? All in favor?
Aye.
Opposed? Okay, 1210, staff report on 1210 is accepted. And that motion passes. Are we ready for 1209? Or not quite? You want a break? Okay. Okay, so we're going to go to item H is a report on the adoption of the Commission Regulations 1211, 1212, and 1214. At this time, I'll call upon law enforcement consultant Mark Nagel and AGPA Katie Strickland, SB2 transition team, to provide us a report on this item.
Good afternoon, commissioners. My name is Katie Strickland with the SB2 Transition Team. My colleague, Mark Nagel, and I are going to be tag teaming this item. So I'll be starting out with Commission Regulation 1211, Peace Officer Accountability Advisory Board, and then I'll pass it off to Mark. So Senate Bill 2 creates the Peace Officer Standards Accountability Advisory Board, and regulation was created to identify the roles and responsibilities of the members of the board. This is a new advisory board to the commission established to review the investigation findings of alleged serious peace officer misconduct and to make recommendations for the commission to act upon a request for review from the subject peace officer. Regulation 1211 addresses the following. 1, it establishes the purpose of the board, frequency and conduct of meetings. 2, it establishes the responsibility of the board in reviewing investigations presented by the division and make recommendations to the commission. 3, allows the board to deliberate the facts in a closed session if necessary. And 4, outlines the board's responsibilities for notifying the commission, the division, and the involved officer or representative of the reasons for the decision.
Thank you. Commission Regulation 1212, the commission hearing on peace officer certification. It was determined that there needs to be a regulation to identify the roles and responsibilities of the commission in reviewing the findings of investigations of alleged serious misconduct of peace officers and determine appropriate action regarding certification. The roles and responsibilities of the commission in relation to peace officer certification include the commission's authority to suspend, revoke, or cancel any certification issued by post, the responsibilities of the commission in reviewing the recommendations of the board, and if adopting the recommendation, the vote shall require a 2/3 vote of commissioners that are present. Adopt procedures if the commission reaches a different determination than the board. Establish the evidentiary standard of clear and convincing evidence. Allow the commission to deliberate the facts of the case in closed session when applicable. Establish responsibilities and notifying the division and the involved officer or representative or of their recommendation for action and provide explanation. Establish procedures for a formal hearing before an administrative law judge, including notification requirements. Establish the commission's responsibility to publish the names of peace officers whose certifications have been suspended or revoked, and establish the commission's responsibility to notify the National Decertification Index of peace officers whose certifications have been suspended or revoked.
Are there any questions as to 1212? Okay, on to 1214.
Last one for this package. 1214 annual reporting requirements. Identifies posts responsibilities to prepare annual reports on behalf of the board to include activities of the commission, board, division, and post participating agencies pursuant to Penal Code Section 13512. This is the new responsibility of the commission, and post is determined it is necessary to codify such factors to provide clarity for the regulated public. The regulation addresses the following. 1, subsections A1 through 10 identifies the items that must be reported annually pursuant to Penal Code Section 13512. And 2, the annual reports must be made available in a manner that allows them to be accessible to the public.
Thank you. Any questions as to 1214? I know Maddie would like to address the group. Yes, please.
Thank you, Madam Chair. No, this is just, I know Chief Commissioner Nieto referenced public comment on 1209 from the American Civil Liberties Union. We also received public comment on Regulation 1211 and Regulation 1214 from the ACLU, and that should also have been in your packet for reference purposes to these two regs.
Thank you. Any questions on 1214? Okay.
Madam Commissioner, could I get back to 1211? I must have missed, I'm tired, so I must have missed questions on 1211. And my only question gets back to the ACLU, and they referenced the presenter for post. I just want clarification from Toby. They were concerned that it would not be an attorney. Do we know who the presenter at this time will be for the case for post?
I don't know that staff has worked that out, but presumably what would happen is that, oh, sorry. I haven't talked to the SB2 team about this, so I don't know for sure. And you, Jackie, you can tell me if you've had these discussions. Generally, what happens is at a proceeding like this, there's sort of a bifurcation of legal responsibilities, number one. And so there would generally be a staff person from the division, presumably, that would be presenting the case before the board. Then an attorney would be either present or would be actually making the presentation before the board. That would be a lawyer that would be separate from the lawyer that would later, so in other words, a lawyer that sort of prosecutes the case or advises or advocates for the prosecution of the case. That would be different from a lawyer like myself, for example, that ultimately would advise the commission sort of as a neutral in terms of what decision the commission would make. So again, I don't know, Jackie, if you guys have gotten to that granular level in terms of the presentation, but my operative assumption was that either council or staff in conjunction with council. And sometimes I've seen, like in other states, as I've watched some of these presentations, there's a staff member that does the presentation, but then there's also an attorney that's representing effectively the division that can be there to answer questions as counsel. So I don't know if you've thought about that issue or not.
Yes, we have, and you're exactly right. We envision that this will be a tandem presentation by both the investigator and the legal counsel, so both.
Anything else? Okay, Jackie, you wanted to go back to, you want to continue with 12-11, 12-12, and 12. We're gonna vote. Yeah, we're gonna, hang on, I got it. But no, I don't mean hang on. You can jump in anytime. We have not yet voted on 12-11, 12-12, and 12-14, nor have we voted on 12-09. So would you like us to proceed with voting on 12-11, 12-12, and 12-14, then go back to 12-09? Okay, great. Did the advisory committee have any comments on this item?
Comments related to item H from the advisory committee have to do with whether or not there was a deadline or a timeline in place for appointing members to the Accountability Advisory Board, and then concerns regarding the transparency of the process for board member selection. And then questions as to what the training would be. Staff indicated that they were preparing a 40-hour training course, and a number of the committee members were interested in attending that course as well. Those are the comments from the advisor.
Okay, thank you. Is there a motion to approve the changes as described in the staff report on 12-11, 12-12, and 12-14?
So moved.
Second? Okay, and all in favor?
Aye.
Opposed? Hearing no opposition, that motion passes. Shall we go on to item 12-13, or do you want to go back to 12-09?
We can go back to 12-09.
Okay, let's go back to 12-09. All yours, Jackie.
Thank you. So if we refer to the proposed regulation and consistent with Toby's recommendation, if we added the suggested language under subsection small b, number 3, then there's the A, B, and C. I would recommend that we make a new letter B with the proposed language of notification will be made in writing to the agency head that employs or employed the involved peace officer of the request for review. And that would satisfy that? Okay, and if we do put it in B, then we'll have to move the current B to C and the current C to D. So we would have to just renumber that section.
The other possibility, would it be possible, Jackie, just to put it at the end of the sentence on 3? If a request is received, the board shall schedule a case for hearing as soon as practical to determine whether clear and convincing evidence exists, period. And then your new sentence would be, in the event that the employee makes the request, we'll notify the agency.
So you're
So that way A, B, and C stay intact. You don't have to renumber it.
oh, we can do that. That's fine. So you're just suggesting that 3 becomes both sentences in the
Two
one.
sentences, right.
That
So if
works,
it's
that's fine.
received, the board shall schedule it for hearing, and then the next sentence is, and we'll let the agency know.
Yes, absolutely. That works.
Okay, so since I'm the pain, I will make the motion to adopt 1209 as just stated and amended.
Is there a second? Question?
Can I do a friendly amendment?
Sure.
Because we need the motion that we change division to the executive director or designee. And what are we doing?
So I will,
A1 and 2.
I will amend my motion to include Commissioner Brazil's comments.
Thank you. Do we have a second?
Second.
Okay, okay, all in favor?
Aye.
The opposition? Okay, 1209 also passes. I'm sure this will disappoint all of you. We only have one more. You've been working so hard, you and your team. Thank you so much. Item I is a report on the adoption of Commission Regulation 1213. At this time, I will call upon Bureau Chief Jackie Nelson, SB2 Transition Team, to provide us a report on this item.
Thank you, Madam Chair, and I'm very glad that you get to start your day with me and end your day with me. So proposed Commission Regulation 1213 is staff proposes to adopt a new regulation to establish factors to consider when determining whether an act of serious misconduct warrants a suspension rather than a revocation. So the regulation will ensure that any sanctions other than revocation are fair and reasonable and not disproportional to the alleged misconduct. As this is a new responsibility to both the board and the commission, post has determined it necessary to codify such factors. These factors were adapted from several different resources, such as the Skelly factors, the Douglas factors, and other licensing bodies in California. And one change to the proposed text, if we may quickly, on number 10, we would like to recommend removing the words praiseworthiness or blameworthiness and just have it the motives of the peace officer that resulted in the conduct.
Any questions about that or the amendment? Did the advisory committee have any comments on this item?
Madam Chair, no comments.
Thank you. Is there a motion to approve the changes as described in the staff report as well as the amendments as to 1213? Second? All in favor?
Aye.
Opposition? That passes. Okay. Future dates, future commission dates. Upcoming commission meetings will be held May 26th. I know you're saying to say 12/22 or 2022 in West Sacramento, September 22nd, 2022 in San Diego, November 30th through December 1st, 2022 in West Sacramento, March 1st through 2nd, 2023 TBD, June 7th through 8th, 2023 post West Sacramento. Is there anything from you?
Yes, if I may, just to put it on everyone's radar for upcoming dates. We've had internal discussion as to if there is an issue or something gets kicked back, how are we going to get it all codified and get it into regulation prior to January 2023? We do not anticipate anything, and hopefully we don't, but we at least wanted to project a possible date should we need to have a commission meeting that will allow us or enable us to still codify the regulations prior to January. Just as a tentative date, should that be necessary, we were proposing the week of August 8th through the 12th with a tentative date of Wednesday, August 10th. And that will again only be if something happens that we need to do some kind of cleanup. Just propose that to
Date
you
is
all.
August 10th as a potential meeting, and I assume would be up here in West Sacramento.
Correct. And we would tell you well, and hopefully well in advance, and we will only tell you if it's necessary. We will not tell you if it's not. How's that? I'm sorry, Commissioner Yule? We can no longer do Zoom meetings, unfortunately. They all have to be in person. We don't anticipate anything coming up. Obviously, we have a meeting on September 22nd. Push comes to shove, we could do it there, but we don't think that's going to give us enough time through the whole regulatory rulemaking process to get us to the January 1 deadline.
Again, the date
We don't want
is
to,
Wednesday, August tenth.
Wednesday, August
a
10th
possible-
is what we propose, yes.
You're giving us warning ahead of time.
We will give you, how much warning do you think we would be able to provide, Jackie or Katie, since you were dealing with the OAL regulatory process?
Yeah, I think we'll know probably by the beginning of July at the latest that we would be able to make that notification.
So about a month.
Yes,
Okay.
preferably even sooner, but
Would you prefer a notification one way or another? It seems like, is that a better thing? I presume that's fine with like, hey, we're gonna have a meeting or we're not gonna have a meeting. Do you have a preference as to what you would like to hear from us?
Commissioner Yule? Preference?
No,
Nope.
okay,
Fair
so
enough.
we'll only notify you if it's necessary. How's that? Okay. And
But
I
it's
think
on-
that also covers, we pretty much have all of our regulations covered for now through the end of the year. We don't anticipate bringing any others to you, correct, Jackie? It's strictly cleanup.
yes, I don't want to say that we won't. At this point, we think we've covered everything, at least as far as we know, but there, you never know what may transpire. So
Okay.
this is certainly the lion's share of them.
Again, great job, Jackie, Toby, everybody on this team, Maria. What a tremendous amount of work in the weeds. So we all appreciate that very much. And commissioners, I think your questions were outstanding. So is there anything else? Hearing nothing, I will call for a motion to adjourn the meeting. Is there such a motion? Second? Okay, the meeting is adjourned. Please don't forget to be there, to be here at 8:30 tomorrow. We need to get those photos done. The commission meeting started and hopefully get out at a reasonable time. Commissioner O'Rourke, would you note the time?
Perfect.